No instructions, my lord.
Counsel petitioner states he has no instructions. Disposed of.
Old matter item number 2.
None appears disposed of non-prosecution.
Special weekly old matter item number 3.
May I please, my lords? My lord, the opposite parties have appeared and they have filed their counter, my lord.
Allowed to see to the petitioner MBBS, ex-serviceman quota. Which year, sir?
My lord?
You want a seat in the MBBS in the ex-serviceman quota.
No, my lord.
Which is the petition number, sir? Please read the petition number.
My lord, item number 3, my lord.
Petition number, sir.
27570.
Wrong list, sir. You're appearing the wrong list.
My lord, item number 3, my lord. 27570 of 2011. Dolo Govinda Muduli is the petitioner.
They've scanned the wrong petition. All right.
Lordship, for the brief, my lord.
Yes.
My lord.
This is the second time it's happening.
Well.
I have prepared a short date chart, my lord, for my lordship's perusal. Lordships may kindly peruse the same.
Where's the date chart?
My lord, I am just.
Who's for MCL?
They have filed their counter, my lord.
Katke, you're appearing.
I'm about to state.
Who's for the MCL?
My lord, on behalf of Mr. Padi, my lord, my lord senior, my lord, we have filed a counter, but as a file has been misplaced and we couldn't, we searched for the file today.
No, Mr. Padi is appearing for MCL.
Yes.
My lord.
Yes, Mr. Padi appeared.
Mr. P.K. Padi, learned counsel for the MCL, states that he's misplaced his file and seeks an accommodation for today.
Pardon.
24th August.
My lord, lordship may kindly give me permission to file a short rejoinder to their counter.
Oh, no, yes, that is already there in the previous orders.
My lord, obliged.
Special weekly list item number 4.
Your Lordship, item number 4, that is 54,643, paltry amount.
The amount being insubstantial, tax amount being insubstantial. The court leaves the question floor open and disposes of the petition.
Special weekly item number 5.
Item number 5, Your Lordship, delay is more than 2 years, Your Lordship.
The delay of more than 2 years is not satisfactorily explained. The delay is not condoned, the petition is dismissed.
Special weekly item 6.
Your Lordship, item number 6, Your Lordship may kindly turn to the question of law. This question of law has already been decided by Honorable Supreme Court, Your Lordship. This entire issue related to entry tax, levy of entry tax on imported goods, Your Lordship. So this Honorable Tribunal, by relying the judgment of Honorable Kerala High Court in case of William Fernandez versus State of Kerala, Your Lordship has allowed the claim of the petitioner by saying that there cannot be any levy on imported goods, Your Lordship. And that judgment of Honorable High Court of Kerala has been reversed, Your Lordship, by Honorable Supreme Court in case of State of Kerala versus William Fernandez, Your Lordship. And also there are many cases of this Honorable High Court also against this Honorable High Court. Multiple cases have been decided by the Honorable Supreme Court by saying that in view of the foregoing discussions, we conclude that goods imported after having been released from customs.
Where are you reading? This is a copy.
Your Lordship, I can give you. Your Lordship, I have given the flag mark, that is the concluding portion. Paragraph 123. In view of the foregoing discussion, we conclude that goods imported after having released from custom barriers are not immune from any kind of state taxation which fall equally on other similar goods and the submission of the learned counsel for the petitioner that immunity from state taxation
Cannot be accepted. All right. You see, the following question of law was framed for consideration by this court when it admitted the present petition on 27 July 2015. This is the following question. None appears for the opposite party despite service of notice. You see, learned counsel of the state refers to the judgment of the Supreme Court in state of Kerala versus Father William Fernandez.
That is, your lordship, reported in 2017 SEC online, Supreme Court 1291.
2017 SEC online, SC
1291.
Where it has been held in para 123 as under you take this flag 8. Consequently, the question is answered in favor of the department and against the SEC by holding that the tribunal was in error in holding that the purchase value of the goods imported from outside the country will be deducted from the purchase turnover. The revision petition is accordingly disposed of.
Get fully.
Special weekly item number 7.
On behalf of Mr. Ekiponda, my matter become infructuous.
Petitioner states the matters become infructuous, disposed of as such.
Special weekly item 8.
Your lordship, item number 8 and item number 10 are identical, your lordship. Your lordship, I have prepared in these two cases in another way, but I have seen an order what your lordship was passed on 28th June, when my learned brother's additional standing counsel has argued the matter. Your lordship was treated that that notification, that amendment is to be prospective, your lordship.
Correct.
But I have prepared that case that without going to even to how the amendment is clarificatory, your lordship, by cognizing the other provisions, your lordship. But since your lordship was already passed,
Correct.
so I have no authority to.
In view of the order dated 28 June 2022, passed by this court in STREV 81 of 2011, bracket State of Orissa versus Messrs. Tarini Minerals Private Limited, bracket. The present revision petitions are dismissed.
My lord, sir, I appear in item 10 on behalf of this one.
All right. All right.
9. Special weekly item 9.
Your lordship, item number 9, your lordship, at page 11, the question of law. That is the 10A penalty under Central Sales Tax Act, your lordship. Your lordship, the question is that whether on the facts and circumstances of the case, the tribunal is correct in, your lordship, your lordship may not read not maybe strike down, in allowing the second appeal filed by the opposite party, particularly when it was apparent from the reply to show cause notice issued by the sales tax officer that the goods purchased from outside of the state of Orissa on the strength of declaration form in C were not utilized for the purpose of for which those goods were purchased, your lordship. And second question is also identical, your lordship. Now, your lordship may kindly turn to the tribunal's order at page 39. At paragraph 7, your lordship, tribunal is the finding that we peruse the orders of both forum below. Can I place your lordship?
Yes, yes.
Your lordship, admittedly, the appellant has purchased the alleged goods furnishing declaration in form C for use in generation of electricity. But he was permitted to purchase those goods as per the certificate issued to him by the learned STO. So it appears that learned STO, without making any inquiry or any adverse material against the appellant, has concluded the appellant has not used those goods in generation of electricity. As per section 10A of the CST Act, if for any reason purchasing goods in guilty of an offence under clause so and so under section 10.
What is wrong with this, sir?
Your lordship, why it is wrong? Your lordship may kindly turn to the first appeal order at page 28. You know, cement and other materials, whatever materials that are not the raw materials, that are not used in generation of electricity, your lordship. Your lordship, at page 28, the second paragraph, peruse the impugned order of penalty under section 10A with the relevant papers and materials available on record. Careful consider the grounds of appeal, your lordship. It is seen that appellant has effected bulk purchases of material like steel, bitumen, spare parts for cranes, spare parts, sea mixer,
No. This is about procedure, but no, without any show cause notice, you simply impose
Your Lordship,
penalty.
show cause notice has been issued, Your Lordship.
No.
Your Lordship, may kindly turn to the assessment penalty order.
Yes.
Show cause notice has been issued.
No, but the tribunal says it was not.
Your Lordship, the penalty order at page 23. Your Lordship,
No,
page 24.
The STO
Page
should have held the
24.
appellant guilty of an offence under section 10B, C or D of the CST Act.
Obviously, Your Lordship, at page 24, so far as the show cause notice, Your Lordship. Hence,
No,
a notice was served upon the dealer fixing the.
STO did not make any inquiry into the contention of the appellant that he had used the goods directly or indirectly in generation of electricity.
Your Lordship, the goods itself, Your Lordship may kindly turn to the penalty order. Your Lordship, handling equipment, spare parts.
That you can't presume these things, sir. You have to make an inquiry.
Your Lordship, for generation of electricity.
You don't know. You'll have to ask for an explanation.
Your Lordship, I have asked Your Lordship at page 24. A notice has been issued, Your Lordship.
Yes.
Hence, a notice was served upon the dealer fixing the date.
You read the page 40. What is the finding of the tribunal?
Your Lordship. He merely on verifying the books without giving the appellant an opportunity of hearing as interfere. Your Lordship, against this, Your Lordship may kindly turn to page 24.
Yes.
The penalty order.
Yes.
At page 23, the details have been given. At page 24, hence, a notice was served upon the dealer fixing the date on 19 February 99 to show cause why a penalty as contemplated under section 10 of the CST Act shall not be imposed on him. Responding the same notice, the dealer had furnished the explanation.
Read on, sir. Continue reading. Don't stop there.
Your Lordship, the dealer has furnished the explanation stating that the above good purchased on the strength of Form C have been utilized by the division under their project for gate work, Indravati Dam and Muran Dam, construction of tunnel, dike works, colony roads, and for running up.
So why is this not for the purpose of electricity?
Your Lordship, this cannot be for generation of electricity.
What else is this for? This
dam work, construction work.
Works and all is for what?
Construction work.
No, for what? It's for the Indravati Dam. It's for generation of electricity.
The registration certificate
No.
itself says that it is generation of electricity.
The state is an appeal. The state has filed this revision petition against an order dated 9 June 2011, passed by the Orissa Sales Tax Tribunal, Cuttack, dismissing the state's appeal being essay number 99(C) of 2001-02. The question sought to be urged for consideration in the present revision petition is whether the tribunal was justified in
It's also for HSD also allowed.
justified in agreeing with the SSC that the sales tax officer was in error in holding that goods purchased from outside state of Orissa on the strength of the declaration form in C. Declaration form C were not utilized for the purpose for which the goods were purchased. Unquote. It is seen from the facts of the case that the purchase of the goods was for the purpose of generation of electricity. Prior to imposing the penalty, the STO apparently issued a show cause notice. To which the SSC filed a reply. This reply was not accepted by the STO on the ground that it was not satisfactory. So the fact of the matter is that, where is that portion of the order you're reading out?
Your Lordship,
24.
page 20.
In the reply, the SSC pointed out that the good purchase in the strength of C form were utilized open quotation by the divisions under their project for gate work, Indravati Dam, Muran Dam, construction of tunnel dike works, Colony Road, and for running of transport and inspection vehicles. Unquote. All of the above works are only for generation of hydroelectricity at the Indravati Dam, and therefore it cannot be said that the goods purchased were not used for generation of electricity. There was no justification, therefore, in the STO declining the, in holding that the dealer had contravened Section 10 bracket D of the CST Act and in imposing a penalty. Paragraph. The tribunal has rightly interfered with the impugned orders of the STO and the ACST, and in deciding the issue in favor of the SSC.
Lord, tribunal is
The court is
allowed,
therefore not inclined to frame the question as urged by the state. The revision petition is dismissed.
Lord, tribunal is allowed on technical ground, Your Lordship.
No, it's all right. Right.
Special utility item 11.
Item 11, my lord, the question already decided, my lord, in another revision case,
Your Lordship.
petitioner, my lord, same order.
The same 28 June. 87.
In view of the order passed with support on 28 June 2022 in ST REV 87 of 2011, the present petition is disposed of in the same terms.
Special utility item 12.
Your Lordship, item number 12. Your Lordship, that notice requisite has
Not been filed. Yeah, the requisites for issuance of notice have not been filed for over 11 years now. The court does not propose to grant any further indulgence. For that purpose, the petition is dismissed.
Special utility item 13.
Item 13, my lord, matter has become infructuous, permitted to withdraw.
Yeah, for the state.
Item number 13 is
13.
13 is ST REV 94 of 2011.
Your Lordship, the question of law is at page 12. Whether on the facts and in the circumstances of the case, the Orissa Sales Tax Tribunal is correct in holding that cement and electrical goods purchased on the strength of declaration in Form 4, specified under entry 48 of the civil goods declared taxable at the sale point, qualifies for claim of availing concessional rate of tax, even those goods are used for construction of
So
townships.
there will be no stay, no notice, nothing issued in this case. We leave the questions of law.
Your Lordship, it is also covered by Andhra Pradesh, Honorable Andhra Pradesh High Court.
All right.
Because it is concessional rate of tax, so it has to be strictly interpreted.
Some old 1991 decision, sir.
Your Lordship. Your Lordship may.
We leave the question open, sir. The petition has been pending for over 11 years now. No notice is even issued. The court, this stage does not propose to reopen the issue by examining the correctness of the impugned order of the tribunal. Leaving the questions of law open for decision in some other appropriate case, the petition is disposed of.
Special utility item 14.
My please, my lords. It's a question of law. Will your lordship kindly see page 6. Page 15, my lords. Sorry. Two questions are admitted by this Honorable Court, my lords. Page 15. Whether disallowance of claim of deduction towards discount by the petitioner by way of credit note is just and proper. Whether the learned tribunal justified to traverse beyond the issues before it and deciding a new proposition, that is grant of benefit of discount within the period for filing revised return, can be sustained in law. Because so far the basic question is concerned with us. Before I take your lordship's attention to the judgments which fully covers the field millers, the petitioner deals in tires millers, company manufacturing, selling tires millers. And as a matter of trade practice, various discounts in different forms are given. And whenever discounts are granted millers, these are granted not on the face of the invoice itself. After sales, as a matter of policy, that is in the assessment order also, they have it is stated that discount like turnover discount, cash discount, for product discount, in special. So these discounts were credit notice issued, and the discount along with the tax component millers, those are credited millers to the account of the buyer millers. So he gets back the discount along with the tax component millers. But what has happened, the total discount millers for this period is 17,524.99. Revised return was also filed. But Learned Tribunal, if I take my lord's attention directly to the findings of tribunal, my lords may kindly see page 32 millers.
Yes.
Paragraph 7 and 8. We have heard both the parties, also gone through the orders of the fora below. It appears from the assessment record that the dealer has issued credit note to the purchasing dealer. As per the provisions of law, discount is being given at the time of sale of the goods. In case of subsequent benefit towards cash credit, the revised return is to be filed within 3 months from the date of filing of original return. In order to find out the truth behind filing of revised return, we called for LCR, but the same could not be produced by SR despite adjournment. If the revised return is filed, that should be finding first about acceptability and thereafter its consideration for assessment. Both the forum below have lost sight of the requirement recording their finding on cash credit. This is cash, not cash credit. This since no lower cost record is available at this forum to verify the correctness regarding.
Matter has been set aside.
Could have been remanded to the STO?
Exactly.
This is remanded. But the findings millers, if that will be millers on remand taken care of by the assessing authority, this will not yield anything. My humble submission is, if your lordship will go by the provisions of law, because the Learned Tribunal has skipped the relevant provisions in terms of the judgment millers.
By now it will all be over, sir. 2011, if it was remanded.
And remanding
no
the
stay
matter,
here.
yes, 2022 may not help neither the revenue nor me millers. And the
No, there was no stay here, no?
millers, yes, I have been directed to pay some amount, I believe.
No, but there is no stay of the impute order.
No, Your Lordship, no stay.
Probably
So
no
by
stay.
now it is, must be over, sir.
No stay.
On remand to the STO in 2011, by now it will be over.
Your Lordship.
You see, the impugned order of the tribunal only remands the matter back to the sales tax officer for a fresh consideration in light of the order of the tribunal. While admitting the present revision petition by the order dated 10th February 2014, 11th February 2014, this court did not stay the operation of the impugned order. Since that is an order of remand made way back in 2011, it must have worked itself out. And it will be open to the petitioner if agreed by the fresh order to seek appropriate remedies in accordance with law. The court sees no purpose in entertaining the revision petition at this stage. The questions of law left open for decision in some other appropriate case. The petition is dismissed.
Yes, sir. Let the tribunal order be carried out, millers. That is what my humble submission. Now that the Learned Tribunal is remanded, let the tribunal's order sustain millers. Accordingly,
That's why we're not interfered, sir. Therefore, we're not interfering with the impugned order.
so this will be now taken care of by the assessing authority millers.
That's right. Whatever the order is passed by the STO, you can seek appropriate remedies.
It is for them now to take a call on these millers.
That's right. That's right. Let them do it.
You also direct them to do it because time.
We don't know if it is done or not, sir. So you'll have to find out.
At
There's
least
no stay here. So by now it will all be over, actually. Yes.
Special Wiki List item 15.
Your Lordship, Your Lordship, I kindly turn to page 12. Whether in the facts and circumstances of the case, the sales tax tribunal committed error of record in holding that the goods brought from outside of the state of Orissa for the purpose of execution of turnkey was contract cannot be subjected to levy of tax under the Orissa Sales Tax Act 1947. Even Your Lordship, admitting, not admitting, not conceding, Your Lordship, I think it may not have any merit, but however, Your Lordship, I have to argue, Your Lordship, at page 26 of the assessment order. At page
So
26.
no notice has even gone in these petitions. For over 11 years now, no notice has even gone in the petition. The opposite party. Court does not propose to reopen the issue of correctness of the order passed by the tribunal more than 11 years ago. At this stage, leaving the question of law open for a decision in some other appropriate case, the petition is disposed of.
Special request item 16.
Your Lordship, item number 16. Item number 16, Your Lordship, Your Lordship may kindly come to the question of law. That is a page 16. Whether on the facts and circumstances the tribunal was not justified in addressing an issue which was neither before the assessing authority nor before the first appellate authority. And also now, Your Lordship may kindly turn to the tribunal's order. Your Lordship, at page 3.
Sir, all of this is the same thing. No notice is even issued in 11 years, sir.
Your Lordship,
At this stage, to reopen, go after those assessees is all pointless. Same order as the previous one. Right. Leaving the question of law.
Your Lordship, because there are many cases are also pending in such a
Yeah,
way.
yeah. But all in good times are not 11 years.
Your Lordship, we have considered done two issues so far as that paltry amount and limitation. But
That's
in
all.
this
This is
way,
one
Your
more.
Lordship,
One more.
there will be no case.
Because if there at least notice is issued,
Lordship,
they didn't appear, that's different.
I'm admitting,
When
Your
notice is
Lordship,
not issued, sir.
But there are many merit matters also that are pending. Your Lordship.
What to do?
16.
Yes.
Special request item 17.
Your Lordship, item number 17. Item number 17 is also that matter has been set aside. Your Lordship, the matter is remitted back to the Law and History for assessment.
Anyway,
and appraise.
none appears, you said none appears, so the petition
Yes.
dismissal is not possible.
Special request item 18.
Your Lordship, item 18 and item 20, both are same.
Yes.
This case also the same aspect. Your Lordship, Your Lordship may kindly turn to the question of law at page 10. Whether on the facts and circumstances of the tribunal heard any material to hold that seats sold by the opposite party would fall within the scope of entry 35 of the list of goods declared exempted from levy of sales tax under section 6. If Your Lordship will peruse without conceding, Your Lordship may not record my concession. But Your Lordship, prima facie on the face of the tribunal's order as well as the lower forum's order, it has been seen. It has been verified, Your Lordship. So
Yes.
I should not argue, but
All right.
Your Lordship may pass the order.
Yeah. In all these three matters, the question of law involved. The question of law sought to be urged by the state. For consideration by this court is common, namely whether in the facts and circumstances of the case, the tribunal had any material to hold that seeds sold by the opposite party well within the scope of entry 35 capital F of the list of goods declared exempted from the levy of sales tax under section 6 of the Orissa Sales Tax Act 1947. Having perused the impugned order of the tribunal, the court finds that factually
It has been
the tribunal has
certified.
in fact found that the seeds sold by the opposite party would fall in the scope of entry 35F. Consequently, the court is not inclined to frame the question as urged by the state. The petition is accordingly dismissed. The petitions are accordingly dismissed.
Item 19. Item 19.
Item 19, Your Lordship. Item number 19, Your Lordship may kindly
You
turn to
said
the
18 and 20 years done, no?
same.
Ah.
18 and 20 are same.
19.
19, 21, 22 are same.
How? Tax effect is what?
Tax effect, much more tax effect is there. Your Lordship may kindly turn to the tribunal's order. This is 3,39,000 tax effect. The tribunal's order at page 31. Whether the value of, in view of the aforesaid contention of the appellant, the only point for determination of the case of these appeals is whether the value of goods purchased by the appellant on interstate sale utilized in the worst contract is to be executed from the amount received by it for assessment of its tax liability. We heard the learned counsel for the so-and-so, the appellant utilized the goods purchased in interstate sale of the works contract executed by it. It claimed, your lordship, so-and-so, so it has been allowed. Now, your lordship may kindly turn to the assessment order. Your lordship, I think for one case, your lordship is allowed. Your lordship, assessment order of pay at page 19. No doubt, the goods have been moved from state to another, but for the benefit of the contractor, the contract has been bifurcated into two, one for supply and other for erection. After the 46th amendment of the Constitution, the bifurcation has no meaning for consideration. The measure for the levy of tax contemplated by Article 366, the value of the goods involved in the execution of works contract. It is wrong to say the value of such goods for levying tax can be assessed only on the basis of the cost of acquisition of the goods by the contractor. Since the taxable event is the transfer of the property in goods involved in the execution of works contract, and the transfer of property, such goods take place when the goods are incorporated in the works. The value of the goods which can constitute the measure for the levy of the tax has been the value of the goods at the time of incorporation. Value of the goods at the time of incorporation of the goods in the work, not at the time of incorporation of the goods in the works, and not the cost of acquisition of the goods in the works, and not the cost of acquisition of the goods by the contractor, your lordship. So for that reason, the assessing officer, considering these aspects, the material transfer are taxed at usual rate as no books of accounts relating to labor. Your lordship, for this reason, this has been disallowed.
Come to the tribunal's order, sir.
Your lordship. Your lordship also.
Page 3, paragraph 5.
Your lordship. It claimed deduction value of these goods of the amount received by it towards works contract for assessment for its sales tax liability. The S2 as well as law did not allow the deduction for value of those goods from the amount received by the appellant for assessment of sales tax liability. Honorable Apex Court in the decision reported in 88 STC Gannon Dunkle and have settled the law that the good purchased in the interstate sale utilized in the works contract will be executed by levy of sales
Will be
tax.
excluded, I think, not executed. Will be excluded for the levy of sales.
Your lordship. Interstate sale or utilized will be excluded for levy of sales tax as the state is not competent to impose tax on such goods, so on so on. So in view of the settled position of law.
The present revision petition has been filed, questioning inter alia, and order dated 7 June 2011, passed by the Orissa Sales Tax Tribunal. In essay numbers 1323 to 25 of 2001-02. Whereby the aforementioned appeals filed by the opposite party were allowed. The reasoning for the impugned order has been contained in paragraph 5 of the impugned order. Where relying on the decision of the Supreme Court in Gannon Dunkle and Company versus State of Rajasthan, 1993, 88 STC 204-SP. It was held that goods purchased on interstate sale and utilized in the works contract will be excluded for the levy of sales tax, as the state is not competent to impose tax on such goods. In terms of entry 54 of the state list, read with Article 366 bracket 29 capital A bracket small b of the Constitution of India. Having heard learned counsel for the state, the court is not persuaded that the tribunal has committed any error. In coming to the above conclusion, no substantial question of law arises. Petition is dismissed.
Specifically, item number 23.
Item number 23 for 5 assessment years, once sales tax revision has been filed, and also defects have not been removed.
None appears to the petitioner. Dismissed in normal.
Specifically, item 24.
May I please, Your Honor? Well, Annexure 1 is under challenge, that is an award of the labor code. I am a private individual. I am a storage agent. The claimant was my power of attorney holder.
Has he been served, sir?
Yes, my lord. Somebody is appearing, but Mr. Jena is appearing.
Where is Mr. Jena?
He was my power of attorney holder. He claimed some money from me, approached the labor court, and labor court, without deciding his jurisdiction, awarded under 33C2.
There is no stay, sir.
Yes, there is a stay order.
When was it passed?
2/12/2013, order number 2.
And then was notice served on the other side?
Well, I have not received any counter. They have not filed any counter.
No. Did they enter appearance?
Yes, madam. The name appears in the list.
We'll pass it over then. Let him appear.
Special legal list item number 25.
Cancellation of lease. This honorable court has already remanded the matter.
It is a case of resumption of the lease order, and he
Yes.
is a purchaser after the before the order is passed. So, your lordship may direct him to file appeal against that, because section 7 of the OGLS Act provides that this order is appealable. As an aggrieved party, he can file appeal before the sub-collector.
So whose order is he assailing?
Assistant Tahsildar, additional. The appeal will lie before the sub-collector Bhubaneswar.
Counsel to petitioner seeks leave to withdraw this petition with liberty to approach the sub-collector in appeal in accordance with law. If such appeal is filed not later than 16th August 2022, it shall be considered accompanied by an application condition of delay
Yes.
with an explanation for the delay on account of the pendency of the present petition. It will be considered on its merits by the concerned appellate authority. The court clarifies it has not expressed any view in the matter.
And the
interim order.
difficulty is we are issuing notice to the lessee. Lessee is coming and appearing before the concerned court, but they are not disclosing that we have already sold it to X. Otherwise, at that point of time, notice could have been issued to this purchaser.
Anyway, you say the status quo order passed by the court. The stay order or status quo order?
There is no interim order, I think.
Yes. There was an interim order. Yes.
What's that interim order date?
And
No. Give us the date of the interim order, sir.
16/4/2012.
Till such time, the appellate authority deals with the application for condition of, for interim relief, provided the appeal is filed within the time stipulated, the interim order passed, this court will continue.
Special legal item number 26. Item number 26.
None appears dismissed. No.
Special legal list item number 27.
None appears dismissed. No.
Special legal list item 28.
Lord, here in this case, my lord, that resumption case has been initiated without giving any notice to the purchasers, my lord. The purchasers have purchased the land way back in the year 1985. Proceeding was initiated in the year 2002.
Same order.
Despite that, may I pray, my lord, let it be remanded to the additional Tahsildar so that will appear.
As an aggrieved party, you have to file appeal before the Tahsildar.
Admittedly, they have
Same order as the previous one. All right.
Special legal list item 29.
None appears dismissed. No.
Special legal list item 30.
None appears.
Special legal list item 31.
Lordship, item 31, I have no instruction in this matter.
Counsel petitioner state.
Lordship, a liberty may be given if any call.
No. 2012 matter.
Madam.
Item 32.
May I please, my lords. May I please. There might be.
Before my learned senior starts, I am for the opposite party number 5, I am also equally aggrieved, but I am supporting the petitioner to the extent I may be heard after my senior completes his hour. Yes. OSFC is there.
Was Orissa State Financial Corporation and Mr. Deo is appearing here. My lord, the prayer of the petitioner is for issuance of the no demand certificate in favor of the company consequent upon deposit of the entire amount. That is, even though my lord, as per the Jimanama, we have deposited the amount, but the Orissa State Financial Corporation, since has not issued the no demand certificate, this writ application has been filed. The Lordship will find it from Annexure 16. I have already filed a date chart. If it is
yes, it's there.
So, my lord, I may permitted to place this same so that it will be easier on my part to convince. I've already filed the date chart if it is there. Shall I place? In the year 98, my lord, M.A. Budyog was put to auction. Anushya Patnaik was the highest bidder. 1198, an agreement was executed with the opposite party to secure the loan. 11-12-98, possession was handed over to M.A. Budyog, the petitioner. 5-6-2000, OTS applied for was accepted by the annexure to sanctions. Petitioner received a show cause notice for non-payment as per the OTS. Petitioner was, however, asked to deposit of settlement amount. Failing, the OTS will be withdrawn. The dispute was regarding the payment of dues of IDCO, which was silent in the auction document. 28-5-2007, the opposite party issued a show cause notice for non-payment if settled dues. 21-7-2008, the opposite party cancelled the settlement order. 18-2015, the opposite party issued a loan recall notice. Here, my lord, 14-2011, the opposite party revalidated the same with a request to the petitioner to discharge the entire liability within 30 days. Otherwise, auction will be taken in accordance with law. 9-8-2011, OSFC asked the petitioner to attend the customer meets for setting the account. 16-8-2011, circular was issued by the OSFC wherein the branches of the OSFC were asked to be very cautious in seizing units. 17-8-2011, in customers meet, the petitioner was asked to make the payment of rupees 6,70,000 by 31-3-2012. 24-10-2011, the petitioner was agreed to pay.
These all are unilaterally. You simply decided you will pay an installment. They never agreed.
So your lordship will find your lordship have a glance to the agreement. That to my lord.
No, they have to agree, sir. You are just proposing that you will pay in installments.
My lord,
they never agreed to it.
No, my lord, have a glance to the page 21. Page 21 of my brief, my lord. There is a page 21. My lord, have a glance. They called me to sit for a closure loan account. My lord got it, page 21. So, my lord, in page 2, your lordship will find there I have been directed to deposit the amount, page 21. Accordingly, my lord, even I could not pay the same. Thereafter, 6-1-2012, there was an auction notice. Correct. For which, my lord, I appeared and they asked me to deposit the 21 lakhs and some odd. I have deposited under Annexure 13. They have accepted. They have accepted, my lord. That will be revealed from page 24 and 25. They have accepted. And thereafter, my lord, Annexure 14, there was a deed of Jimanama. And thereafter, my lord, they have handed over the position also. And your lordship will find from Annexure 14.
Sir, you never paid the installments. You never paid payment. You just gave yourself some time. That was not agreed to by the other side.
We have to accept the OTS, which is a.
My lord, they have accepted the OTS and I have deposited the amount. And your lordship will find Annexure 15 and basing on the Annexure 14, my lord, I have deposited the amount which will be revealed from Annexure 15. That is, Annexure 15 is series and 21 lakhs and some odd I have deposited, and because there are some delay, they asked me to deposit another 2,41,000 and I have also deposited. After they have accepted the same, since they have accepted the same, my lord, they have not issued the no demand certificate. And that to my lord, on the last occasion, there was a circular which I have enclosed. On the last, my lord, may have a glance to the last order passed by this Honorable High Court, where your lordship has directed the OSFC Council to. My lord, I'll have a glance to the order dated 25/4/2018. Basing on my rejoinder, where I have enclosed a document where they have extended the, that is letter dated 3/9/2000, basing on the 3/9/2012, this Honorable High Court on 25/4/2018 asked the OSFC Council to obtain instruction as to why they have not taken Your lordship will find from the my rejoinder I have enclosed. My lord, if your lordship will
was made as per the circular.
My lord, I have a glance to the circular of the OSFC dated 3/9/2012, where my lord, basing on that, the amount has been deposited, and that is the reason on the 25/4/2018, this Honorable High Court has directed the OSFC Council that, to my lord, I have a glance to the order number 424, dated 25/4/2018. This order is like this. Mr. Ashok Mahathir, senior advocate, enters appearance for the petitioner, files appearance memo in court today, which is taken on record. Harshi Ashok Mahathir and counsel for the petitioner says uncharged. Law and counsel for the petitioner files a death chat in court, which is taken on record. Copy of the rejoinder affidavit filed by the petitioner is served on Sri Anil Dole and counsel appearing for the Orissa State Final Council today, who prays for some time to go through the same and take instruction in the matter. So, my lord, since that if your lordship will find from the annex, page 7 of my rejoinder, this is the circular issued by the OSFC,
And accordingly, the amount has been paid as per
and
the
basing on that, my lord, the amount has been paid. So they are required to accept the same. What happened, my lord? After I have deposited the amount, my lord, they have somebody has said that I will pay 50 lakhs, but without depositing any amount. That is the reason, my lord, the Orissa OSFC has said you are required to pay the rest amount that you have already paid 29 lakhs and another 20 and some more you are required to pay. So that is the reason, my lord. But basing on their circular, basing on the agreement, I have deposited the entire amount.
There's no agreement to receive it in installments, sir. You pay the entire amount on a date of your free choice. You don't pay it within the time stipulated.
My lord,
There is a default. These are financial companies.
yes, my lord. But financial corporation accept the money, and also as per their instruction, my lord, we have deposited the amount.
There's no instruction, sir. They asked you to deposit. You yourself unilaterally decided you will do it in installments. They never agreed to that.
My lord,
according to this High Court has
my lord, as per the circular dated 3/9/2012, the amount they are required to accept, and
there's no compulsion on them to accept whatever you give, sir. There is an amount due. You're supposed to pay that amount. If you want to pay in installments, they have to agree to it. You don't wait for them to agree. So you simply say, I will pay in installment.
My lord, we have paid the, even for delayed payment, we have paid 2,41,000 as interest.
Yes.
Your lordship will also find. My lord, that is a direct decision your lordship will find. In a similar identical matter. My lord, have a glance. The single lordship will find the petitioner, who is a director of the OSFC, has approached this court seeking issuance of the direction upon the OSFC to allow it to avail the benefit of settlement of its loan dues in terms of the one-time settlement OTS scheme, and also prayed for quashing of the notice under Annexure 7 series to the writ petition. Petitioner took a loan of rupees 1,40 lakhs to set up the factory subject to terms and conditions stipulated in the loan agreement. It is submitted that the petitioner has repaid some amount and thereafter applied for settlement of the dues under the OTS scheme. After careful examination of the application of the petitioner, the OSFC intimated the petitioner by letter dated 26/10/2009 that OSFC has agreed to settle the term loan account of rupees 12,60,000 with certain terms and conditions, and that was to be paid by the petitioner on or before 24/2010, or in 4-month installment, which starts from 24/12/2009 to 24/2010, as per Annex 1. However, petitioner could not pay the same as per the time stipulation. Therefore, OSFC issued show cause notice on 2/6/2010 to
Facts
the
are different, sir.
No, my lord, this is a
Not identical facts. These are not identical.
Here, my lord, they have the amount has already been deposited. After I deposit the amount even, and after they have made there was an agreement to that effect, Jimanama. Now, my lord, they have said because somebody has offered more, even without depositing any amount, that is the reason why the OSFC said you are required to pay the balance amount. So it cannot be because I have already deposited the amount. From the beginning, the petitioner said, I am ready, I am not in a position to, because due to the super cyclone, everything was collapsed at that time, and that is the reason why he could not pay. And that too, there was several circular has been issued by the OSFC for relaxation of that, and basing on that OTS, I have applied, I have deposited the amount. Your lordship will find from the annexes the receipt I have deposited. And even after the loan was about only 6,70,000, and I have paid about 29 lakhs, my lord. And
that usually happens, sir. These are all compound interest. So it will,
even if
amount will be far more than the principal.
Your lordship will find, my lord, I pray your lordships to see they have called me for a discussion, and I appeared before them, and there was a decision also taken under Annex 21 to pay the amount, and I have also page 21, they called me for a discussion for closure of the loan account, and I appeared, and they have said that you are required to deposit. There was also, they have also said under Annex 10 page 21, they said that you are that extension they have given till 31/12/2011, but after 6 days they have advertised for auction on 6/1/2012 under Annex 12, my lord. But on the next on 16/1/2021, my lord, I have deposited the entire amount of 21 lakhs, and for delayed payment, my lord, for delayed payment.
What do you say?
Please, your lordship. Your lordship may kindly say, para page 6, my lord, paragraph 12, my lord, he has applied for OTS, my lord. That was, they have issued notice that Annexure A/1, page 9, that outstanding dues is to pay, settle the amount on at the rate of rupees 12,44,000. And in the same year, it was requested to pay outstanding dues of the cyclone loan, NEF loan, as per loan agreement. Since these loans are not covered under OTS, he remained silent and he has not honored the settlement order of the issued by the person and failed to settle the amount. Thereafter, the opposition party cancelled the settled order, my lord. Thereafter, the recall notice was issued. By the time it was total outstanding was 72 lakhs, my lord. In the meanwhile, opposition have taken the possession of the same, and advertisement was made. My lord and friend here, and your lordship may kindly see when he has appeared before the DDSC on 16/1/2012, my lord. He has requested for release of the unit on payment of rupees 21 lakhs immediately towards balance settlement amount on our OTS scheme, which has been earlier approved in favor of the petitioner, although the validity period of OTS has been already been expired since 31/12/2011, my lord. That has already been expired.
The petitioner also committed to pay the delay period interest. If any under OTS lax scheme by 31/2012, in case the same will be approved by the board of directors of opposite party, he has agreed and paid rupees 21 lakhs. The petitioner further requested to committee for release of the unit of the GMA. The unit was released on GMA, but there was a condition in the GMA that he is to pay the entire amount subject to this decision of the board of directors, my lord. Board of directors, whatever board of directors will decide, they will be bound by this, my lord. Your lordship, in the meanwhile, for the public interest and interest of the corporation, either advertisement made and received 7 number of offers, my lord. 1-3 on negotiation 1-3, Gain Patra submitted the offer, that is 50.50 lakhs, my lord. That is the point, my lord, that he has paid 21 lakhs. The corporation subsequently filed annexure section 6112 directed to for payment of the differential amount, my lord. That outstanding was 72 lakhs, but he was given opportunity to 50 lakhs. That was the decision of the board of directors, my lord. Your lordship, I can see board of directors decision, annexure G/1.
G/1.
Page 23, my lord, page 10 to 23.
Of the counter?
My lord, page 23.
Yes.
OTS proposal of MS Sukhdev Jagatpur Kotak, the board perused the memorandum, and after going through the details of the case observed under, the borrower has given opportunity to settle the loan account at the under OTS scheme, but due to non-payment of the order of the settlement was withdrawn on 21/7/2000. The borrower did not apply under a subsequent OTS scheme allotted by the corporation. In order to recover the DDUs, the unit was seized on 18/11/2011. The borrower was given the opportunity to settle the dues under OTS scheme by 31/3/2011, but could not do so. Subsequently, to advertisement for sale of the property, the borrower appeared before the DDSE on 16/1/12 and deposited 21 lakhs with a request to release the unit and settle the account under OTS scheme by condoning the delay period. DDSE after going the stipulated offset price and highest bid of the 50.550 lakhs decided to release the unit in GMA to borrower on payment of 21 lakhs and subject to usual terms and conditions applicable and also condonation of a delay under OTS 2.50 lakhs scheme by the board of directors of OSFC. After discussion, the board did not agree to proposal for condonation of delay for settling the due.
All right, sir. All right. Yes.
He was asked for differential.
So, my lord, it is not as per the agreement. We have deposited the amount. What? Because the board has said that you are required to deposit, and I have deposited the amount on 16/1/2012. So, my lord, it is not that you have not deposited. That to the circular which has been issued by the OSFC, they are bound by that. They cannot unilaterally reject the same. That to, my lord, the offer which has been offered given by one NPAP, that was not on record. And that to, my lord, he has also not deposited an amount, just merely saying that I am ready to deposit, that will not do. So the petitioner has deposited the entire amount. And now...
When is the question, sir?
My lord?
The question is when?
We have deposited... After, my lord, they have directed me to deposit by the annexure 10 by 31/12/2011.
Yes.
But we have deposited the amount on 16/1/2012, just after 15 days, my lord.
Yes.
We have deposited the amount. Now, my lord, they have also, accordingly, there was a Jimanama. But the board of director has, subsequently, the board of director has taken a decision. No, that cannot be given to her. We have deposited the entire amount as per the term and condition. Now, well, subsequently, the board of director has taken a decision. Subsequently, the board of directors has taken a decision. Well, that cannot stand because they should be governed by their own circular. There is a benevolent circular to that effect. And after the super cyclone, my lord, since there was all the units were damaged at Jagatpur, my lord. The government has, the OSFC has taken a decision for OTS, and accordingly that has been done. This poor lady has paid already 21 lakhs since long. But subsequently, my lord, the board can and even, my lord, the petitioner also deposited the interest amount for delayed payment. The petitioner has also deposited. Now, my lord, subsequently the board cannot say that that since somebody has offered more, you are required to pay that.
All right. We're not inclined. The petition is dismissed.
So, my lord, if you say, then I can ask my client to come with some more amount so that it can be shared.
No, right.
Special vehicle list item number 33.
The 33 my lord, demand notice has been issued
My lord,
without following.
I'm sorry. In this case, I am for the opposite party number 5. Lord, this opposite party number 5, in fact, I have filed a petition for transposition under Order 23 Rule 1A because the entire amount with OSFC was deposited by me. I was made a partner. My question comes after whether the beneficiary, the OTS beneficiary should be extended to them or not. My part will come thereafter. But now your lordship
You
has
seek
to be
independent
satisfied.
remedies, sir. We are not entertaining her petition. You seek independent remedies.
Yes. Since what
is their application
what I
number?
would suggest, my lords, what I would pray, we will make a representation before the authorities. Your lordship may kindly mention that, and as per the norms, whatever is due, we are ready to pay that. Because I have already substantially been, I cannot use the word, I have paid him, I have paid to the OSFC. I am now the person who is in distress now.
Yes.
So what I would pray,
You want to withdraw your application, you withdraw it.
I am opposite party number 5. I am my intervention was allowed, and I am opposite party number 5.
So we're not entertaining it, sir.
If your lordship will observe that it is
Your lordship may kindly
for the petitioner to,
or else my entire amount goes. I cannot realize a single pie from OSFC. Neither I can realize from him nor from the OSFC. May kindly consider my prayer.
All right.
Item 33.
Item 33, my lord, demand notice has been issued without following the principle of natural law.
All right. Same order.
Of similar matters.
Same order.
Same order.
Item number 34.
Can your lordships hear me?
Yes.
I'm appearing through VC. In this matter, I have been instructed the opposite party number 1 has died in the meantime. So if my learned friend appearing on behalf of the opposite party number 1 can give the details so that we can file the application for substitution of the legal heirs.
What's the matter about?
This is a labor matter where the award has been passed. It was the categorical submission of the management that he has not worked for 240 days. There was no evidence on record before the labor court that he had worked for 240
He can't be reinstated. It's only 25% back wages now.
No, my lord, but there is a question here. He was working only for 1 or 2 days a month in the absence.
So what is 25% back wages? What will it work out to?
No, my lord, whatever it is, even if it is 25%, your lordships will appreciate that this is a wrong order.
Some widow will get it now, sir. If he has died, there's nothing left now in the matter.
I'll just submit before your lordship. We have no idea whether he has really died. We have just been informed. Your lordship may adjourn the matter for a week. Let us confirm his death and then come back to your lordships.
Who's for the other side? Who's for the other side, sir?
I don't think anyone is appearing as of now, but there is.
Then all the more, sir.
There is someone who's appearing. He has entered his appearance. I do not have the name with me. There is someone who's appearing for the other side.
What does this 25% work out to?
Your lordship.
What does this 25% work out to, sir?
I'll just take instructions and get back to your lordships within 1 week. Your Lordship, I adjourn the matter for, I do not have any idea how much this 25% will work out to.
The request to consider the petitioner list next Monday. Right.
Very grateful.
Special vehicle item 35.
Your Lordship, I am appealing for the workman, opposite party workman.
None appears to the petitioner dismissal not possible.
Special vehicle list item 36.
36, my lord, this is a single bench, single judge matter, my lord.
Council list before the learned single judge as per the roster on 9th August.
Special vehicle list item 30.
Sorry, on 10th August. Special weekly list.
37. Item 37.
None appears for the petitioner dismissal not possible.
Item 38.
Lord, I am there for the opposite party corporation, my lord.
May I please, your lordship. Sir, my lord, challenging the award, the present widow who has been rehabilitated under the opposite party in the year 1993, he has been terminated with effect from 6/9/2021 and raised the dispute, saying therein that I was initially appointed because my husband was there in regular employment. After his sad demise during the course of working, she was appointed under the rehabilitation assistance scheme. So when he has been terminated on 6/9/2001, a dispute was raised. And finally that award was passed. Kind of a glance to Annexure 1 at the relevant pages, page 21, my lord, the operating part.
Have you got this 1,50,000 or you have
Yes,
not?
my lord. I have received the 1,50,000.
Huh.
Lord, after receiving, he has filed this writ application.
Oh, I see. Did you receive it under protest?
On protest, my lord.
Where is that letter of protest? Where is the letter of protest, sir?
My lord, that I have not annexed, my lord.
Then you have not filed a rejoinder also. In the affidavit, they clearly say you filed it after receiving the amount.
My lord, 2000 judgment is there of the Honorable Supreme Court.
Sir,
Even
if you
if I
receive
have-
the amount without protest, then how can you challenge it?
My lord, even if I have received, because I am in
supposed to
distress
leave it.
condition, so I will not be precluded to challenge the
No,
award,
of
my lord.
course. If you in terms of the impugned award, if you accept the full amount, where's the question of challenging it after that?
Once the award is implemented, it is
Correct. That's the end of the matter. An affidavit
My lord,
counterfeit has been
because I
filed
was
the
in
present
distress
petition
condition,
on 26th April 2022, pointing out that after accepting the entire payment of rupees 1,50,000 awarded by the tribunal as compensation in lieu of reinstatement, and without protest, the petitioner has filed the present petition challenging the same award. As rightly pointed out by the opposite parties, if the amount has been accepted without protest, it is not open to the petitioner to turn around to challenge the award thereafter. On this short ground, the petition is dismissed. Yes.
Special
my
legal
lord,
item
my lord,
39.
it was received on protest, my lord.
There's nothing to show that, sir. Yes.
Item 39. Special vehicle list 39.
None appears dismissed non possible.
Item 40.
None appears dismissed non possible.
Item number 41.
40.
Item.
And item number 40, no instruction.
Okay. 40, you say dismissed, no instructions dismissed. Okay. 41.
41.
My lord, in this case, I have challenged the assessment order. I may be
Same
permitted
order.
to file.
Counsel to petitioner seeks leave to withdraw this petition with liberty to file an appeal in accordance with law if such appeal is filed not later than
My lord, delay.
10th August 2022,
Delay maybe.
accompanied by an application for continuation of delay, citing the pendency of the present petition as the reason for the delay. It will be considered on its merits in accordance with law. The
My
court
lord, interim order
states
is
that
also
it has not expressed any view in the matter. If the appeal is filed within the time indicated, accompanied by an application for interim relief, then till such time an order is passed in that application. The interim order passed with this court on 28 September 2012 shall continue. The originals be returned subject to being substituted. Attested photocopy thereof. The petition is dismissed as disposed of as withdrawn with liberty as paid for in the above terms.
Special liquid list item 43.
42 is over.
Item 43.
None appears dismissed. Not possible.
Special liquid list item 44.
No instructions, my lord, on behalf of Mr.
Petitioner
SBJ.
states he has no instructions. Dismissed as well.
Item 45.
Your lordship, item number 45, be permitted to withdraw.
Counsel petitioner seeks leave to withdraw this petition. Dismissed as withdraw.
Special liquid list item 46.
None appears dismissed. Not possible.
Item 47.
46. 46 dismissed.
Item 47.
None appears dismissed. Not possible.
Dismissed. So
Liquid list item 48.
None appears dismissed. Not possible.
Special liquid list item 49.
May I please, Your Lordship? No instruction, my lord.
Counsel petitioner states that he has no instructions. Both petitions dismissed.
Special liquid list item 50.
None appears dismissed. Not possible.
Special liquid list item 51.
None appears dismissed. Not possible.
Item 52.
No instruction, my lord.
Counsel petitioner states he has no instructions. Petition is disposed of.
Special liquid list item 53.
53, my lord, the matter is pending in an SLP with an interim order. My page 11 of my so-calls. I am the alleged contemner 1.
Counsel to petitioner number opposite party number 1
My lord,
states that
page 11 is the order.
4513 of 2012 filed by the Orissa State Financial Corporation against the judgment dated 28 October 2011 in petition civil 19729 of 2010 is still pending. There is already a stay of the operation of the order dated 28/10/2011 of this court. None appears for the petitioner. In view of the above stay order, the present petition can obviously not continue. Depending on the outcome of the above SLP, it will be open to the petitioner to file a fresh petition in accordance with law. The petition is disposed of.
I'm obliged.
Special liquid list item 54.
I am for the opposite party.
None appears dismissed and not possible.
Special liquid list item 55.
Item 55, Your Lordship, may I please, Your Lordship? Lordship, in this matter, under Annexure 3, the petitioner made a representation before the opposite party number 2, Your Lordship, for release of the amount for completion of the work, Your Lordship. Lordship, kindly refer to Annexure 4 at page 10, Your Lordship. The same has been accepted by the opposite party in Annexure 4, Your Lordship. It is the amount is rupees 3,06,630, Your Lordship. But the same still has not been recovered to the petitioner, Your Lordship.
No, but because you have completed just come to that same next paragraph.
Yes, Your Lordship. After that, Your Lordship, under Annexure 5, I have given them an undertaking.
No, that's not simply an undertaking. You have to complete the work.
Yes, Your Lordship. I have completed the work.
These are all disputed questions of fact. Can't be gone into a repetition.
No, Your Lordship. What I pray before Your Lordship, just kindly allow me, as I have already completed the work and the JE and the project administrator has already submitted the report on that.
Petition for recovery of money. You have to file a suit.
Lordship, I will file a representation before the opposite party.
That's not the remedy, please. The remedy, if it's in a contract, your dues are not being paid to you, you have to file a suit for recovery.
Indeed, Your Lordship, but as because under Annexure 4, they have accepted the amount.
That is up to you. We are not here to give you free legal advice. We only will not entertain this writ petition. That's all.
Lordship, kindly just allow me to file another fresh representation.
We don't have to allow you. You do whatever you have to. The court is not prepared to entertain a writ petition where the prayer is for release of money, which is allegedly due to the petitioner for performance of his part of a contract. The appropriate remedy lies elsewhere. The petition is accordingly dismissed.
Obliged.
Special liquid list item 56.
No, 56 might be infructuous because second appeal stay revision.
All right, none appears dismissed, not possible.
Item 57.
57 is also infructuous.
Yes. None appears dismissed, not possible.
Special liquid item 58.
My lord, 58, 59, and 60 infructuous.
Infructuous dismissed.
Special liquid list item 61.
None appears dismissed.
Special legal list item 62. Item number 62.
62.
None appears dismissed. Not proceed.
Special legal list item 63.
May I please, Your Lordship? So in this case, Lordship, kindly see the last order. In this case, this honorable court direct statement take instruction since long Miller. In it is whatever the petition is assailing the inaction of the opposite settled land as per the notification of guide as per the notification. Miller. The present petitioner has undergone tuberculosis operation and obtained the green card holder. Annexure 1. But as per the term and the condition of the green card holder, you kindly see page 11. The person should get a land, homestead land up to 8 decimals. Miller. Since the present person has been possessing more than 30 years, 30 years, and she applied for the authority to settle the land, but the government Tahsildar has not taken an action.
My lord, merely because somebody is occupying a land without any authority for 30 years, that cannot be a ground for settling the same. But in case the petitioner desires, he should go in procedural law for not that by filing a writ petition, he will ask the writ court to direct the authority to settle the land in his favor. Let him file under the OGLS Act or any act which is prevailing for loan and that for lease, and that will be decided in accordance with law.
Kindly see page 10, Miller. What are the term and condition those who are the green card holder, Miller? As per the government resolution 34700 dated 1983, Miller, that notification governed in field till now, Miller. Person those who have been done on tuberculosis operation, and the government should allot 8 decimal land as per the page 11, clause 2. Clause 2, Miller.
You're able to read, sir. Page 11, you're able to read.
Sir, benefit to which green card holder are entitled.
You're able to read.
Yes, preference.
Sir, I want to give you an award now.
Sir, yes, sorry, Miller.
Your eyesight is wonderful, sir.
Sorry, Miller.
No, you're sorry. You should be very happy.
No, I'm
neither of us is able to read, but you're able to read. How come?
Yes, I'm sorry.
What award shall we give you, sir? We are unable to read. Just show that annexure.
Page 11.
Let us see.
Page 11.
Mr. Monty is able to read.
Page 11.
I am also not.
Benefit to which green card holder?
Sir, are you able to follow what we are trying to tell you?
Sorry. Well,
He is claiming that I am a green card holder, I am entitled to certain benefits. Yes. But that is a subjective satisfaction of the lease granting authority. Yes. And you have to apply before the, not that you will invoke the writ jurisdiction of this honorable court directly and get an order. You have to apply before the appropriate authority. And if you are satisfying the ingredients, then the authority will take care of your prayer.
But he seems to have made representations.
Yes, he has made the representation. Not representation. He has to file a lease case before the Tahsildar. Appropriate, because there is a format.
Counsel to the petitioner, it appears that counsel to the petitioner is seeking benefit of a resolution passed by the government, copy of which is at annexure 1, seeking allotment of some land in her favor. Counsel for the state points out that the appropriate course of action that the petitioner should adopt is to file a lease case for grant of lease in her favor before the Tahsildar, invoking the appropriate provisions of the concerned statute, leaving it open to the petitioner to avail of such alternative remedy. The petition is disposed of.
Yes, sir. Legal list item 64. Item number 64.
None appears dismissal, not possible.
Yes, sir. Legal list item 65.
64, man. I'm sorry, Lord. I was just.
Yes.
Lord, this matter, before I take your Lord, it's a matter involving representation of the management before the industrial tribunal, industrial court, labor court. I had taken notice on 18th of March 2013. I don't think
nobody's
the list
appearing.
is, no lawyer name is appearing. If anybody is appearing, then can be taken up tomorrow after verifying. Otherwise, he will come to judice.
Neither AD card nor unserved notice is back on sole opposite party.
Notice is.
Oh, no. AD received after valid service.
So it is presumed to be sufficient.
Right. Then what's the grievance, sir?
Lord, the grievance here is, Lord, the tribunal has rejected my application form G for representation, saying that I am a person who is not in the regular payroll of the management. I wanted to represent the management, and management wanted to represent.
That matter is still pending. Is the matter in the labor court still
should
pending?
not have been. Should not have been since 2013.
No, but yes. All further proceedings were stayed. On 18th February 2013, there was a stay of all further proceedings.
Yes.
All right. The present petition has been filed challenging an order dated 11th January 2013 passed by the Central Government Industrial Tribunal cum Labour Court, Bhubaneswar, in ID case number 5 of 2011. Declining permission to the legal advisor of the petitioner to represent the management for the tribunal. It is submitted by, you say, despite a service of notice on the opposite party number 2 workman, none appears. Paragraph. It is submitted by Mr. Rakhar, done at conflict to the petitioner management, that its legal advisor had been representing it throughout, and there's no reason for the labor court to have tribunal to have rejected. No, to have disallowed the legal advisor to represent the petitioner company. In fact, such representation was allowed by an order dated 5th April 2011. The application by the opposite party number 2 for disengagement of the legal advisor was filed only after the petitioner objected to an application by the opposite party number 2 seeking permission to engage a lawyer on his behalf.
In fact, he's not a lawyer.
So that person apparently is not even a lawyer. Paragraph. Since there is no opposition to the present petition, the court set aside the impugned order dated 11 January 2013 of the tribunal and permits the petitioner to be represented by its legal advisor in the tribunal. Petitioner is disposed of in the above terms. A copy of this order is sent forthwith to the concerned tribunal, before which the aforementioned ID case number 5 2011 will be listed on 10th August 2022 for directions.
Special list item 65.
For being proceeded with in accordance with law.
Great.
65.
65, my lord. My pleasure, Lord. My lord, in this case, the petitioner, being a poor and landless lady, my lord, under Annexure 1 was allotted 140 decimal of land under Annexure 1, page 13. Your lordship, can you see that order? Everything was inquired by the Tahsildar, and when she found is the eligible person, the page 14, the lease. Hence, the order that the following land is settled in favor of Tilotama Dei, wife of Krishna Chandra Maharana of village Srirampur under classification of Bajafasal, subject to confirmation by SDO.
Impugned order of the sub-collector must be an appealable order. No?
And forwarded.
Section 3, my lords, Section 3 deals with settlement of government land. And here is a case where Tahsildar has not settled. Tahsildar has recommended it to the sub-collector for confirmation. Sub-collector has denied to confirm the proposal of the. If he is aggrieved, he can take recourse to Section 7 of the OGLS Act and file appeal before the collector.
All right.
My lord, your lordship, can you see, thereafter,
appeal is available.
Since sub-collector did not pass any order, thereafter she repented from time to time to the sub-collector, and
Yes.
as would be clear from Annexure 3 series.
But the sub-collector is finally
now the impugned order is sub-collector's order.
Yes.
The Annexure 3 series, your lordship, can you see that 17, Tahsildar.
Sir, are you following what he's saying? He's
Now,
saying the order of the sub-collector is appealable before the collector. You see,
appealable. My lord, now the sub-collector, thereafter, this court also reminded the matter to the sub-collector.
sir, now the sub-collector has passed an order that is an appealable order.
My lord.
You see?
No, it is not OGLS Act.
Then
it sub-collector did not pass any OGLS Act under, my lord. Your lordship, can you
Under
see?
what law did he pass an order then? Under what law did he pass an order?
My lord, sub-collector.
It is
Even
only
if it
government
is-
land. Section 3 empowers for settlement of the land in favor of private individuals. It is all government land. And your lordship will see the handing of the sub-collector. It is a land which is reserved for government developmental work.
Your lordship,
And in the meantime, some must have been progressed some work. My learned friend, I have no current
No,
instruction.
possession was asked to be maintained. This as an interim order.
Anyway, let him file appeal.
Your lordship, can you see that page 5 of my writ petition, the earlier order passed by this Honorable High Court reminded the matter to dispose my representation, and also till disposal of my representation, status quo was granted.
All right.
As per the report of possession given by RI as well as Tahsildar Balagada.
Right.
But the impugned order itself, your lordship, can see, it is purely ex parte order without hearing under Annexure 5. So it is liable to be reminded matter to the sub-collector.
How many times? Nothing.
Rather, filing of appeal will be more beneficial.
Ex parte order for the last.
You can raise that point also before the collector that I was not heard.
13 years,
challenge in the present
7
petition.
years, no counter has been filed, and it is
Order dated 20th November 2012 passed by the sub-collector in Revenue Miss Appeal number 1 of 2012.
no hearing is
Declaring
there.
release
The
to the
entire order sheet itself filed under Annexure
Apparently, the
5.
said order is appealable to the collector under Section 7 of the OGLS Act. Accordingly, while permitting the petitioner to avail such remedy, it is directed that if such appeal is filed not later than 17th August 2022,
My ground is that
accompanied by an
ex parte order,
application
my
for
lord.
condonation of delay, citing the pendency of the present petition for the delay, it will be considered on its merits by the appellate authority in accordance with law. Court clarifies it has not expressed any view in the matter. If the appeal is filed within the time stipulated, accompanied by an application for interim relief, then till such time the appellate authority passes an order thereon. The interim order passed by this court on 15th May 2013 in the present petition will continue. The petition is disposed of in the order.
This is legal list item 66.
None appears dismissed from this.
Well, till then the status quo maintained.
Yes.
This is legal item 67.
None appears dismissed from opposition.
This is legal item 68.
68 may not no instruction. Yes. Council petition states he has no instructions. It is dismissed.
67 also, my lord, no instruction.
Same order in 69.
Item 69.
May I please, your lordship? Lordship, may I be permitted to place the matter? Place the matter on behalf of Mr. BP Tripathi.
Yes.
69.
69.
69, your lordship is calling.
Yes.
Sorry, ma'am.
None appears to the petitioner dismissal notice.
Special legal item 70.
70, madam.
But 69. I will pardon to mention that on behalf of Mr. Ponda, as he seek, short adjournment will kindly be given. Item 69.
What is it, sir? What is the matter about?
The matter is that the petitioner was allotted a piece of land from the government as his homestead land, homeless. But the government, while constructing the road, has encroached upon the land. And while he approached the concerned authority, they didn't listen to him.
I think the prayer is very ambiguous. Your lordship will.
Then Mr. Ponda will submit. I have no file also. He has only requested me to take a short adjournment.
Which
There is
Mr.
no
Panda,
issue.
sir?
My lord.
Bring the mic down.
Who is Mr. Panda?
R.N. Panda. Ravinder Panda.
R.N. Panda. The impugned order is at page 6. That is the Tahsildar's order. In this
appealable.
case number 486 of 95. Then it is when the borrower was not.
This is only not to disturb possession. That's the only
Yes.
prayer.
It is just like a suit for injunction.
Ah,
It is just like a suit for permanent injunction.
correct,
There is nothing is impugned in this writ petition.
correct, correct.
He is saying that Garwar is in my favor, let them not be allowed to disturb my possession. That is why I said that the prayer is not at all attracting 226. Let them file suit if they are the rightful owner
Yeah.
and anybody.
You say the only prayer of the present petition is
Or a
that the
press petition.
petitioner's
Liberty will be
possession.
given to file a press petition.
Yes, yes.
Yes.
Counsel, the petitioner seeks leave to withdraw this petition with liberty to seek other appropriate remedies as may be available to the petition in accordance with law. The petition is disposed of as withdrawn with liberty spread for. All right.
Special legal list item number 70.
I may be pardoned, item number 67
Yes,
on behalf of Mr. Patnaik.
yes.
My lord, let it come next week.
No, no, no. What is the matter about, madam?
My lord, that is a resumption against the resumption order without noticing the.
Yes, LDD is prior to the injunction order. That same order appeal will be filed before the sub-collector.
I see.
He is a purchaser before the resumption order is passed. So
All right.
as an agreed party, he is entitled to.
All right.
My
The
lord,
challenge in the present petition is to order dated 26th October 2002, passed by the additional Tahsildar Bhubaneswar in WL case number 838 of 72. The petitioner, who claims to be a purchaser from the original vendor prior to the cancellation of the lease, was apparently not issued notice prior to the passing of the impugned order. On that short ground, the impugned order dated 26/10/2002 is hereby set aside.
No, my lord, your lordship is in all cases allowing them to file appeal against that order before the sub-collector
I may
without
be
setting
pardoned.
aside. Let them file appeal before the
My
sub-collector
lord, in
against.
the similar
No,
cases.
this is additional Tahsildar.
Yes.
Let it go back there, sir. If he's
Yes,
an
my
earlier
lord.
purchaser, not a subsequent purchaser, let it go back. The matter will be remanded. That WL case number 838 of 1972 is remanded to the court of the additional Tahsildar for being proceeded with in accordance with law. After hearing the petitioner, the matter will be listed before the additional Tahsildar Bhubaneswar on 17th August 2022, on which date the petitioner will appear before the said authority, along with a certified copy of the present order. Additional Tahsildars thereafter requested to proceed in accordance with law and dispose of the said WL case number within a period of 6 months thereafter. Till such time, the status quo order till then that's it. It's already been set aside. All right. That's it. The petition is disposed of in the above terms.
The Tahsildar must have corrected the ROR in the meanwhile. That is why.
No, there's an interim stay.
Correction of the ROR. Possession, correction.
No, not possession. There's an interim stay of the order itself.
Obliged.
Urgent.
Special weekly list item 70.
My lord, please, your lordship. Your lordship may come to Annexure 3, page 12. This is a case of reference by the central government. Your lordship may kindly have a look at the reference schedule yourself. Page 12, your lordship.
Yes.
Whether it is justified on the part of the workman, Sri Hadibandhu Mahanta, not to receive the terminal benefits offered by the contractor, Mrs. Pradeep Mining and Construction Private Limited, Jajpur Road, Odisha, on the ground that he should be paid wages for the period from 7/4/2012 to 4/9/2012, actually not worked. If not, what really the workman is entitled? Your lordship, frankly speaking, I have not been able to understand the scope of the reference, your lordship. Such type of reference is just like a post office, the reference is central government.
Correct.
That is one unfortunate part in this case, your lordship.
Correct. And
that
this
is why
reference is at the instance of the management, looks like.
No. Reference is on the instance of the workman, your lordship. Workman, your lordship.
How is a reference saying he's not justified in receiving the terminal benefit?
No, he is saying that since I am entitled to some wages.
So it should simply say, was he entitled to wages for this period? That's all.
Yes, that is exactly the part, your lordship. But the period he has not worked, he admits.
I know.
My lord, this reference has been made in response to the failure of conciliation processing.
I know, but what is this term of reference?
My point is, my lord, in this case, the employee, he has approached to the Ministry of Labour Secretary to make an amendment in the reference. While the matter stood thus, the employer had filed this case. That's why the amendment could not be proceeded.
So we'll anyway say both of you agree that the reference should be properly worded. It's not correctly worded. Constable, the workman admits that the reference as made by the order dated 6/2/2013 is vague and indecipherable. And in fact, the workman himself apparently has approached the Ministry of Labour and Employment for amending the terms of reference. In that view of the matter, the petition is disposed of, stating that the reference will not take place on the basis of the question referred to in the order dated 6/2/2013. But further steps will be taken depending on the decision on the workman's request for amending the terms of reference.
Your lordship, there can always be a better reference in a fresh reference, your lordship.
Correct.
But the amendment cannot take place, your lordship, by resubstituting the entire thing. That is the law.
Correct. The better course, instead of amending the course reference, would be to make a fresh reference of a fresh question, properly worded.
Yes.
It is so ordered, the petition is disposed of.
My lord, I am appearing for Union of India in this case, my lord.
All right. Both petitions are disposed of.
Yes.
Special liquids item 71. Item number 71.
None appears disposed of, non-prosecution.
Special weekly list item 72.
May I please, my lord? I am challenging the. Mike. I am for the petition of my lord.
May I pardon one thing? Item 72, I am for the opposite party. The opposite party has taken consent from the meeting from last
Your lordship,
1 month.
It's all right.
Your lordship has already covered by other period of this opposite party already your lordship has covered by other petition 8008 of 2008. Your Lordship's,
So
that is for another period. This petition is for another period, my lord. Already Your Lordship's covered because he has not come to join and disobey the order of the management.
which is this period, sir?
That is a period
Counsel appearing at the outset, counsel appearing for workman states that the workman has already discharged, taken back the papers from him. None appears for the workman. Paragraph.
This is for the period 198 to 4/4/2000.
Where do you get that?
My lord?
Where do you get that, sir?
That is from the first page, my lord. First page of my writ petition, my lord.
No. What period does this cover? This order which you handed over?
That is that period, my lord. Is that period for let me that period that is from October 93 to December 97. Your Lordship's order in 2008.
What period, sir?
That is October 93 to December 97.
Where do you get that?
My lord?
Where do you get that from the order, sir?
Not from the order, my lord. This is my file, is my brief is with me, my lord.
October 93 to?
October 93 to December 97. And this is for 98 to 2000.
All right. The present petition is directed against an order dated 18 March 2013, passed by the Labour Court Bhubaneswar in industrial dispute miss case number 61 of 2008, which is an application filed by the opposite party workmen under section 33, capital C, bracket 2 of the Industrial Disputes Act 1947, bracket ID Act, claiming rupees 116,984.25 towards subsistence allowance at the rate of 75% for the period 1198 to 33/2000 during the period of his suspension. Paragraph. Another writ petition had been filed by the management, being writ petition civil 8008 of 2008 against another order dated 18th August 2007 of the Labour Court in ID miss case number 229 of 1997. In another, being another application filed by this very opposite party workman under section 33 capital C bracket 2 of the ID Act pertaining to the period October 1990, claiming subsistence allowance for the period October 1993 to December 97. That writ petition was allowed by this court on 24th February 2022 by setting aside the impugned order of the Labour Court. Paragraph. In as far as the facts are identical and the present petition pertains to a later period, that is 1198 to 33/2000, for the reasons stated in that order, the impugned order of the Labour Court is hereby set aside. The petition is disposed of.
Special Utility Item number 73. Item 73.
None appears dismissed for non-constitutional.
Special requisition item 74.
None appears dismissed for non-constitutional.
Item 75.
Lordship, the demand under which the writ application was challenged, the demand has already been paid by the
Constitutional petition states that the petition has been rendered infructuous, is disposed of as such.
Special requisition item 76.
None appears dismissed for non-constitutional.
Item 77.
I mean, issue was made 77, 76. In that case, I am with the Union of India. That is in connection with the settlement of postal insurance. And your lordship passed the order of stay subject to condition that 25,000 would be paid. We have already paid that amount. In meantime, probably the other side is, you are appealing. No. Other side you might have appeared. Let it come next week so that. Item 70. In case the death occurred within 2 months from date of taking of the policy. Therefore, inquiry is envisaged before filing, settling the claim. And we had inquired and found that it was suffering from heart disease before taking the policy. Award was for 50,000 with 8% interest. We had challenged that and interim stay was granted.
What is that? 50,000 is nothing, sir.
My lord?
50,000, is it any amount to be challenged?
50,000.
Why are you dragging a person like that to the court for some 50,000 rupees?
25,000 as per the order in this case, we have already paid. We have challenged that.
Why should you challenge it, sir? Are you so poor? You're unable to pay 50,000 rupees to a workman.
Your lordship may pass the order.
You say the challenge in the present petition is to an award dated 29th April 2013 passed by the Permanent Lok Adalat for Public Utility Services, Sambalpur, in PLA case number 13 of 2012. It is seen that the PLA has passed an order requiring the petitioner, that is the Superintendent of Posts, Sambalpur Division, to pay a sum of rupees 50,000 with 8% interest to the opposite party. Which is an which as it is an insubstantial amount. Full stop. It is seen that this court had, while directing notice to issue in the present petition on 16th September 2013, stayed the operation of the impugned order, subject to the petitioner paying rupees 25,000 to the opposite parties. That amount apparently has been paid. Since the amount involved is insubstantial, and it seems unfair to drag the opposite parties into litigation over such a small amount, the court is not inclined to interfere. Accordingly, the writ petition is dismissed.
Special legal list item 77.
May I please your lordship? In this matter, I have challenged the award passed by the London Labour Court, Bhubaneswar, on for a illegal termination of service of the petitioner. The two issues were involved in this matter, and the issue number 1 is answered in my favor. So far, issue number 2 is concerned, I am in this court. So far, issue number 1, it is decided that there has been a violation of principle of natural justice, and the termination as it is illegal. So far, issue number 2 is concerned, I will draw your lordship attention to page 43, that is annexure A by
You are the management.
I am for the petitioner.
No. Which is what, the workman or?
Yeah, workman.
So the impugned award orders your reinstatement.
Order reinstatement, but so far back wages is concerned. Here he has stated that no back wages, held entitled to any back wages in absence of any evidence to the effect that during period of his employment he was not gainfully employed.
Correct.
That I do admit. But he being a workman, he was not aware that an affidavit has to be filed.
That's all right, sir. So why is the Labour Court wrong? The Labour Court is not wrong.
So
the limited challenge, the present petition by the workman,
at least if some
the award dated 4th March 2013, is only to the extent that while ordering his reinstatement, the Labour Court declined to pass any order regarding back wages. open quotation, in absence of any evidence to the effect that during the period of his unemployment, he was not gainfully employed elsewhere, unquote. Concept of the petitioner states the petitioner was perhaps not aware that he was required to file an affidavit to the above effect, and therefore he should not be deprived of the back wages. In the absence of such an affidavit, the Labour Court was justified in declining back wages. The court is unable to find any error having been committed by the Labour Court in that regard. The petition is accordingly dismissed.
Special Legal List item 78.
So item 78, no instructions. No instructions dismissed.
Item 79.
My lord, item 79 play for next week, my lord. My file has been misplaced.
What's the matter about? So let's see.
I could not recall the matter, my lord. So it is a matter of 2013, my lord. So kindly grant 1 week time, my lord.
On compensation for lack of eyesight.
Due to intake of illicit liquor. That is his allegation.
Oh. He has consumed illicit liquor, lost his eyesight, and he's seeking compensation.
That too from a person who is not authorized to sell that. That is a subject matter your lordship will decide. And he was treated by an Ayurvedic doctor, and after 2 days he went to the hospital, and there is no medical certificate annexed that due to
that the opposite party number 6 is not a licensed guy.
No, he is a licensed guy. But we say that his liquor we have tested, and that is okay. That test report we have annexed as Annexure A/2. So where from he got this illicit liquor and how he fell ill, and after 3 days he complained that my eyesight, and he didn't lodge any FIR. On the other hand, our IIC of Junagadh PS, he lodged an FIR, and then proceeding was the criminal proceeding was initiated.
What happened in those criminal proceedings?
That I have to take the instruction.
Mr. D.K. Monthi, learned AGA, seeks some time for instructions on the present status of the criminal case that have been instituted arising out of the incident of the petitioner having lost his eyesight due to consumption of liquor purchased from the shop of opposite party number 6.
That is, my lord, Junagadh PS case number 127 of 2012.
Yeah, that is Junagadh PS case number 127 of 2012. Right. At his request list on 12th September.
Special Legal List item 80.
Right.
May I please, your lordship. Here, my lord, I have asked 2 orders, my lord. There is a case, my lord, of 2013, the similar case, my lord. The OP number 6 has approved this court challenging the same order. This honorable court, the division bench of this honorable court has already passed it. I have already supplied, my lord.
Where is that?
What's your order?
On 2/9/2013. The same
It's
order.
already set aside.
It is already set aside. In view thereof, my lord, I may be permitted to withdraw the same in view of the order passed by.
Says that at the instance of opposite party number 6, writ petition civil 20139 of 2010 was filed in this court, challenging the very same impugned order. And by order dated 2/9/2013, this court allowed the said writ petition and set aside the said impugned order. In that view of the matter, the present petition, he seeks to withdraw the present petition in terms of since the above order covers the prayer. The petition is disposed of as withdrawn in the above terms.
Great.
Special Legal List item 81.
None appears dismissed, non-prosecution.
Item 82.
Lord, item 82, I pray, let it come next week because I am not tracing that file. This is with regard to, Lord, the compensation of a girl in which she has a 50% disability. For R&R policy, she is deserving for the same, but she is not getting the same. That's why, Lord, but I am not tracing that file. That's why, Lord, I pray.
This has to be a civil suit, sir.
Please.
You want easementary right and all that, you have to
No,
file
my
a civil
lord,
suit.
as for Land Acquisition, my lord, Act and the policy that has been subsequently merged in 2013, and he has, my lord, the right for the getting the same.
No, you'll have to file a suit, sir, for all this. This is
That
civil remedy.
The prayer itself indicates that he needs some easement
Right of
over-
passage.
Yes, right of passage.
Given the prayer in the present petition, where the petitioner is claiming a right for herself and her family members
No, I don't know. My lord, sorry, this is not that matter.
to use plot number 572/909 under Khata number 348 of Moza BJB Nagar, PS Badagada, District Khurda, for their only easementary right. Oh. None appears to the petitioner dismissal non prosecution. The interim order is vacated.
Special legal list item 83.
None appears dismissal non prosecution.
Special legal list item 84.
Mr. Dash is in this maybe. 84.
84.
The 84 matter, my lord. I'm sorry,
Yes.
my lord. This 84 matter, my lord.
Yes.
This is with regard to, my lord, that getting of the rehabilitation assistance scheme under my lord, Land Acquisition Act. And there was a provision for granting that, and it was assessed that she is more than 50% disability. That girl has
So
more than.
there was an order that she should appear for medical examination.
My lord, she appeared. She appeared, and thereafter.
Thereafter, the matter was not heard. So what is the test result?
My lord, I have to take instruction.
Mr. D.K. Manthi, learned counsel.
My lord, I am not also tracing that file also. Your lordship may put any date next week. I will contact this.
And that report, the petitioner should submit. That is my. Lordship may kindly have a glance over annexure A/3 of my counter affidavit. This is the.
It's in Orissa.
No, my lord, it is in English. Certificate for the persons with disability. 45%.
Is that not enough?
I have also not served with the counter also. Let them serve the counter.
No, they have a counter. Maybe they've not served a copy on you.
My lord, they have not.
Copy of the counter affidavit of opposite parties 2 and 3 be served on counsel to the petitioner within 3 days. The court will also be informed on the next date.
My lord.
The outcome of the medical examination. Supposed to have been held on 5th May 2014. In terms of the order dated 16th April 2014 of this court. List on 14th September.
Special legal list item 85.
85 on behalf of Mr. Manas Mahapatra is seriously ill. 1 week time may be given.
What's the matter about, sir?
Matter about challenging the award, which is the expert award. So I have.
Which one, sir? 85 is what? What is the item number?
85.
No. KP Enterprises.
KP Enterprises. Manas Mahapatra will argue the matter of support to he is ill, my lord. That is.
Counsel to the petitioner stated to be unwell. List on 21st September.
Special legal list item 86.
May I please allow? In this matter, I have come up with a very limited plan to consider for a direction to provide legal head of the petitioner under rehabilitation assistance scheme. My representation is still pending under Annexure 3. If your lordship can dispose of the matter with the direction to consider the same, I will much.
The petitioner's representation. Bracket Annexure 3 series. But how do you know you've sent it, sir?
I'll have to take instructions.
It is NTPC. There's nothing, it's only a handwritten representation, sir.
Handwritten.
There's nothing to show it's been received by NTPC.
There is no.
You better withdraw and make a fresh representation. Counsel, the petitioner seeks leave to withdraw the writ petition with liberty to make a fresh representation to the NTPC for appropriate reliefs. As post office withdrawn with liberty is straightforward. All right.
Special legal list item 87.
Item number 87, the prayer has already been decided by Honorable Supreme Court. What?
Anyway, none appears to the petitioner. Dismissal not possible.
Special legal list item 88.
88 became infructuous, Your Lordship.
Counsel, petitioner states petition has been rendered infructuous. Disposed of as such.
Obliged,
Special legal list item 89.
My lord, I am for the petitioner. Today I am filing a wakalatnama on behalf of the petitioner.
This has come back from Supreme Court, sir.
Yes, my lord, it has been remanded, my lord.
Correct. So tell us.
So actually, my lord, till today, the opposite parties has not filed any objection to the writ petition.
All right.
So they required to file an objection to that effect for a detailed hearing of the case.
You are appealing to the opposite.
Yes, I am fully banned.
Do you have any objection? Because the main ground is that the documents you want
The documents must be produced.
Yes, some documents, but this has been clearly dealt with by the DRT. I kindly see the order of the DRT, which is impugned here.
Right.
There, he wanted to call for certain documents relating to some loan accounts which have already been closed long since.
I see.
Now, considering the limited jurisdiction of the court, DRT, under section 17, and under section 17(2), my lord may kindly see, the jurisdiction of the DRT is to see whether there is any illegality in the action taken by the bank under section 34.
This is Surface Act or the other one?
No, Surface Act. Section 17 application was filed before the DRT, and this application was filed in that 17 application to call for the records. 17(2) may kindly see.
Yes.
My lord, much prior to the opening of the petitioner's loan account, there was
let him finish, sir. Then you answer. Yes. 17(2).
This 17(2), that court's jurisdiction is to see.
No, just read 17(2).
My lord.
Kindly read 17(2).
My lord, I'm pleased. The Debts Recovery Tribunal shall consider whether any of the measures referred to in subsection 4 of section 13 taken by the secured creditor for enforcement of the security are in accordance with the provisions of this act and the rules made thereunder. But this is action is taken for recovery of the loans by enforcing the security against the security. But that it is admitted the loan is secured by a mortgage against which the bank has proceeded. That is admitted. But what he wants to call for the earlier loan documents which have since been closed, say 3-4 years before this loan was granted. But that my lord we will see in the order, impugned order itself. My lord may kindly see that is annexed here as annexed 2 to this writ petition. Page 17, my lord may kindly see that.
What is your prejudice if you produce these documents, sir?
But there is no prejudice. Well, my lord, we can, my lord, allow this proceeding to be extended. This proceeding, under section 17, that is time and again it has been held. But this jurisdiction is limited.
What you have done is, sir, from 2011, the matter is not moved.
This was lying, my lord. My lord, this is I tried my best to get it listed. But my job is to file memos, move. But
It could not be.
No. The point I'm saying is because of your objection and the stay passed by this court, the DRT proceedings have anyway not moved forward.
No, DRT.
And then he went to the Supreme Court and got the matter remanded.
That is true, my lord. That is, my lord. The matter has been remanded, but my lord may kindly consider, if your lordship permit me, I will also file an affidavit indicating, my lord, there are several points which the DRT has dealt with.
Are these documents available with you, sir?
My lord?
Are these documents available with you?
My lord, that I cannot say. My lord, it's a long since closed accounts. Long since closed, my lord, is this. Retaining these documents for unlimited period.
So you produce and file an affidavit to that limited extent, sir?
Yes, ma'am.
The matter has come back to this court, has been remanded to this court by the order dated. How come that's not even scanned here? The order of the Supreme Court is not there. Pursuant to which this matter is listed, that order is not scanned. Let's see if it's scanned. Pursuant to an order dated 6th May 2022, passed by the Supreme Court of India in Civil Appeal number 3669 of 2022, whereby the order passed to this court on (31st March 2021). Disposing of this writ petition. Has been set aside. And the High Court has been directed to decide and dispose of the main writ petition within a period of 3 months. Paragraph. The challenge of the present petition is to an order dated 3rd January 2011, passed by the Debt Recovery Tribunal, Orissa, Cuttack, (DRT), rejecting an application filed by the present petitioner under section 17(1) of the SARFAESI Act 2002. Seeking directions to the opposite party bank to produce seven or eight. How many original documents?
My lord.
How many original documents?
My lord
asked for?
Yes, my lord. My lord.
Page 12. Come to page 12.
Page 12. My lord.
How many documents, sir?
1, 2, 3, 4, 5, 6, 7, 8.
7, 8.
8 and 9.
Nine
documents.
Documents. Paragraph. Considering that the bank had not filed a reply to the writ petition, despite notice having been issued initially in the writ petition way back on 21st January 2011, and considering that on that date, further proceedings for the DRT had been stayed. The court considers it necessary to direct the bank to file a reply to the present writ petition and indicate therein whether the aforementioned 9 documents as listed out by the petitioner in its application 1 of 2011 for the DRT are available with the bank, and what prejudice would be caused to the bank if such documents are copies of such documents are provided to the petitioner. The reply of the bank be filed within 2 weeks.
Your lordship may kindly fix on date. Another aspect, my lord, this application, not essay, this surface application, but that is also barred by limitation.
So we are not concerned about all that.
But that is
You're
long
not-
after.
Whatever you want to say, you say it in the written.
Yes,
Rejoined that to be filed before the next date. List on 28th July.
Obliged. Special legal list item 90.
90, my lord. Writ applications are disposed of on 7/11/2012. Kindly take a glance to para 2 of my miscase number 6803/13. Direction was passed to the OP number 2 to remove the encroachment of canal and other public road in.
Sir, this is an application filed in 2013.
Yes.
We are now in 2022.
Yes.
And
how does
some
it survive?
personal allegations have been made against the then Tahsildar by naming him in the.
He says this application has been pending for over 9 years and has not been moved till date, leaving it open to the petitioner to file a fresh application. If any cause of action survives, the application is disposed of. Right.
Special legal list passport matter item number 24.
My lord, there is another 90 additional WPC 10411 of 2013.
All those are disposed of, sir.
All the writ applications have been disposed of with a direction to the OP number 2 to take action.
All right. Yes. What's
Item 24.
None appears disposed.
Special item 24, my lord, that was passed over.
24.
Now the award of the labor court under Annexure 1.
Udit Ranjan Jena.
Yes.
Your Lordship, I'm appearing on virtual mode on behalf of Mr. U.R. Jena, Your Lordship.
Yes.
Your Lordship, we have not been able to trace out the file actually, Your Lordship.
All right. Counsel for the opposite party states that you're unable to trace out the file and seek some time. List on 12th October.
Obliged, Your Lordship.
Weekly list.
Well, that
weekly list.
Interim order to continue, my lord.
Nothing will happen, sir. Nothing has happened for 10 years now. Yes.
Weekly list for orders item number 1.
Let's straight away draw Lordship's attention to the question of law framed at page 6, my lords. My lords, here, by the order of the Honorable Orissa State Tribunal, my goods for which I have already paid first point tax have been subsequently taxed again. That is the whole challenge, whole gamut of the challenge, my lords. They have disallowed the said goods they have not disallowed the said goods and taken it in the taxable turnover. Hence,
what's the tax effect, sir?
Well, my lords, the tax effect is somewhat around 1,22,000. But the problem is I have a refund of 3 lakh something. So the net effect is something around 4.85.
But questions have not been framed till date.
My lords,
till date, no question has been framed.
My lords, the matter was not taken up irrespective of my multiple.
No, it was listed on 4 occasions.
My lords,
but no question has been framed.
There's a limitation. There is a limitation issue, my lords.
How much daily?
363 days delay, my lords. 363 days, my lords.
What's the explanation? Let's see that.
Yes, my lords. The explanation is, my lords, actually, my lords, the mistake lies at the council's end, my lords. The file was misplaced in the shifting, my lords. The council had constructed his house in 2000, way back in 2009.
Can't be for 363 days, sir.
My lords, the point of law, my lords, is in my favor.
We'll leave it open, sir.
Because it's a mistake at the part of the council. Can it be?
Right. Yeah, 360. There's a delay of 363 days in filing the present revision petition. The explanation offered that it was open petition due to the fault of the conducting council, unquote, is vague, where it was, is vague and gives no detailed explanation for the inordinate delay in filing the revision petition. Consequently, the court is not inclined to condone the delay. Miss case number 148 of 2015 is dismissed, leaving the question of law open for decision in some other appropriate case.
My lords, may I
the revision
suggest
petition is also dismissed.
My lords, may I suggest one thing, my lords? My lords, because of the council's fault, the assessees would not suffer. My lords, a cost may be imposed on the council. That will be the right thing to do, my lords, and let the matter be heard on merits, my lords. So
No,
that's
sir.
a question of law is very suitable, my lords.
All right. All right.
Weekly list item 2.
Much obliged, my lords.
My name may be recorded.
Item number 2.
None appears dismissed and not prosecuted.
Weekly list item
1
number
minute. This case stands adjourned to 1/8/2022.
Item number 3, my lord.
1 minute. 1 minute, sir. Oh, where is the order passed to this court? Ah. There's a 17th May order. There's an order of 17th May. A letter has been received from the Orissa State Commission for Women, dated 28 June 2022, requesting time for submission of the report by 11 July 2022. The time is so extended. Stop. List on 1st August 2022, the date already granted. A copy of this order be communicated to the Orissa State Commission for Women forthwith by the registrar. All right.
weekly list item number 3.
Lord, item number 3, my lord, matters related to rehabilitation appointment scheme, my lord.
Correct.
Defects may be removed within 3 days, my lord. In the meantime, my lord, amendment petition is also there, my lord. So I have filed the amendment petition as well as also cost title, my lord. Amended cost title.
All these amendment applications are allowed.
Yes, my lord.
The consolidated cost title is taken on record.
Has 2 sub items, my lord.
Right. In first 2 sub items, 10185 and 2021. In the remaining, you say
defect may be removed within 3 days. My lord.
The other defects be removed within 3 days. The replies have been filed in all of this. Mr. Manti?
Yes, my lord.
He has filed replies?
My lord. Apex court is, order is also there, my lord.
No, they have not filed replies.
Yes, my lord. In other case, my lord, filed, my lord.
Which other case?
My lord,
So far as this case is concerned, the office
which is to be listed on 27th July, my lord.
Correct. So list on 27th July. In the meanwhile, replies be filed in these petitions.
No, they have not supplied copy to us.
Copies of the petitions be served on this month today itself. Right.
My lord, in other case, in another case, my lord, already filed, my lord. Counter already filed, my lord.
But that are
Which
not.
school mass education department?
Oh, school and mass.
School and mass.
Yes.
No, these 4 petitions have replies been filed.
No, my lord.
So I've asked them to file, therefore.
But this is the similar matter, my lord.
That's what.
Maybe.
So if they want to file, they can file in this also, sir.
Yes, let it be.
List on 27 July.
My lord, then he should serve the copy on school and
That
mass.
I've said.
Mr.
Yes,
Polita.
Copies be served on the school and mass education, council of the school and mass
And also for GA, and also for GA department, my lord.
Oh, GA department is there, then.
Yes.
IRS has been challenged, man. That is GA department is a district department.
As well as the GA department. Within 3 days.
Then you survey copies.
Right.
Weekly list item 4.
Not the, though it's a PIL,
there are defects,
defect with regard to, must be with regard to not giving a notice.
Ah.
Blood,
if I can request your lordship, the prayer before your lordship will be very simple. Lordship would-
Representation.
That is a road provided to the
44.
AIMS.
No,
AIMS
no,
is
not
catering.
AIMS. In the comprehensive development plan, page 44, lordship will kindly see BDA has earmarked a 100-feet road. CDP itself provides. Now
This
this varies.
representation, was it handed over? Nothing to show it is handed over.
Apparently, my lord, there is nothing. If your lordship permits us, we can. My lord, what I will
Make
try.
a fresh representation, sir.
My lord, BDA and GA department, they should take a joint call and resolve the matter. We are not in issue with the AIMS because the property has been given to the.
Oh, there's some postal thing. Okay. The representation dated 26th February 2022, bracket annexure 4 series, shall be examined by whom?
By Secretary, Special Secretary, GA department and BDA, Bhubaneswar Development Authority. They are opposite parties.
Secretary.
Opposite parties, four ending.
As
My
well
lord,
as who need to
lordship
develop
may
the
kindly say that additional secretary come director of estates.
As your lordship.
additional secretary come director of estates,
GA department.
GA department.
And BD.
And after hearing the petitioners
And other stakeholders, because AIMS
and other stakeholders, including the Bhubaneswar Development Authority and AIMS Bhubaneswar, a decision will be, a reasoned order thereon shall be passed not later than 14 November 2022 and be communicated to the parties within a week thereafter. The court clarifies it is not expressed any view in merits.
Right. We are not creating any impediment for AIMS. We are just securing 100-feet road. That's all. Wherever they may give us.
All right.
Weekly list item number 5.
Item number 5, the date of the impugned order has been roundly typed in the index and page 11. Madam. So that is the defect. I have filed an amendment petition.
All right. The amendment petition is application is allowed.
But I am permitted to substitute the 3 pages.
The consolidated petition be filed within 3 days, within 1 week. List on.
Weekly list for admission item number 6.
My lord, on last occasion, your lordship directed that whether the establishment of OP, that Nilachal Ispat Nigam Limited, has been taken over by Tata Long, my lord.
Yes.
My lord, the process is going on shortly, my lord, so that I can substitute the Tata Long, your lordship may
All
come
right.
2 weeks after.
At the request of counsel, the petitioner list on 15 September.
My lord.
Weekly list item number 7.
None appears dismissed now.
Weekly list item number 8.
Lordship, no instruction.
No instruction disposed of.
Weekly list item number 9.
9, your lordship directed status of the vehicle to the opposite parties.
My lord, I am on behalf of opposite party number 2 to 4 and on behalf of J. Patnaik. We have yet to receive instruction and I may pray that this may be adjourned and taken up next week.
And so far as, my lord, the status of the vehicle is concerned, my lord, I have downloaded from the RTO site. Aaj and date is started in my name of the petitioner, my lord. Aaj and date.
Oh.
They have seized the vehicle. By virtue of the order of the district forum, I uploaded the goods uploaded in the vehicle. Thereafter, I withdraw the petition and file a petition before the authority that I am ready only to pay the deposit the amount. Your Lordship, the Bhai Annexure 1.
Who are you for? You're for the RTA, right?
No, I am for the petitioner. Here.
Oh, you're for the petitioner.
Yes, yes.
Oh.
They have seized the property and misused the property as per my instruction.
Counsel for the opposite parties need some more time for instructions. Mr. Satpathy in the meanwhile states that the truck is still standing in the name of the petitioner.
I've just sent over the copy of the downloaded from the RTO sites.
As per the details available on the net. List on 1st August.
Pages.
Weekly list item number 10.
I may plead, Your Lordship.
Yes.
The petition of Lordship seeking a direction to the state authorities to take over my institution, which is a primary institution which was established by the local people
through a private management in accordance with law, my lord, which was subsequently recognized. But previously, the petitioner had to approach your lordship. Lordship kindly turn to page 32. Yes, my lord. Page 32, my lord.
Yes.
After due discussion, Lordship kindly turn to not waste your lordship's time. Page 34.
Yes.
As it appears, there is no bar for taking over the school in question and placing it to Project Primary School in SPD, OPEPA and Annexure 11 will not be a bar. That apart, in absence of any counter affidavit to dispose the reputation directly opposite party to consider the case of petition of is the light of decision taken in the case of Kopabandhu Primary School and will take a decision within a period of 2 months from the date of receipt of the order. Then your lordship can see inquiry was conducted, Annexure 10, 11 was report submitted, where the inspector of schools categorically directed that we are entitled to be taken over. Then my lordship can see the rejection order. I'll precisely make my submissions without wasting your lordship's valuable time. Then Annexure 10, Annexure 13, page 41.
Yes.
Then your lordship can see page 43. The other 12 schools, the other 12 schools, though were not considered in the meeting, could not be recommended on account of the remarks noted against each. My school is serial number 1. Dinabandhu Vidyapitha, Karadapalli. The proposal of the Dinabandhu was not recommended since there is the existence of primary school named Parthapur Primary School within 1 kilometer distance set, which is not on facts. Then you'll also go to next page. Serial number 8. Page 44, serial number 8. Maguni Charana Balasantra Primary School, not recommended. One neighboring primary school named Mathari Government Primary School is within 1 kilometer. That school, along with the present school, was also challenged before this Honorable Court. This Honorable Court, after hearing so far the serial number 8 is concerned, allowed the writ application and directed to take over. I've given the judgment of the tribunal as well as the apex court. Apex court also upheld it.
All right. Show me.
So, but serial number 8 is done. Ground of
No,
rejection.
where is this? You said there's some orders there, no?
Order of the so far serial number 8 is concerned.
1 minute. Peculiar facts.
Peculiar facts. And rejection is 1 kilometer, within 1 kilometer. That will also get from serial number 1 vis-a-vis serial number 8. We approached, our case could not be disposed of. They approached, Lordship allowed the application, the state approached the Supreme Court affirmed it. Now they have already implemented and taken up the schools.
Yes, what do you say?
My lord, so far as the serial number 8 is concerned, my lord, this submission I have to take instruction. But my lord, in our counter, our ground is that whether this is a purely private unaided primary school. Whether taking over a private unaided primary school, it is the absolute prerogative.
Not private, sir. Maguri Charan, that's serial number 8.
My lord, so far as that serial number 8, my lord, I have to, because this submission was made for the first time before this court today, my lord.
Instruction,
Right.
On instruction, that I have to take instruction. But
Mishra, Learned Senior Counsel for the petitioner, and draws the attention of the court to an order dated 7th February 2012 passed by this court, petition civil 28285/2011. Bracket Maguni Charan Balashram Primary School was the state of Orissa, where in similar circumstances where the takeover was not being acceded to on the ground that there is a neighboring primary school within 1 kilometer distance, this court directed the government to take over the school. That order was apparently challenged by the government in SLP Civil 31397 of 2012, which was dismissed by the Supreme Court of India on 17 July 2017. So Mr. Mishra accordingly established that the school in question, the Dina Nidhi Vidyapitha Karadapalli, right?
Yes, ma'am, Karadapalli.
Which is a school involved in the present petition, should also be taken over by the government, since it stands on a similar footing. counsel appearing for the S&ME department states that he needs to take instructions. That is request list on.
I'm requesting.
I'm going to solve it.
19 September. 19 September.
Obliged.
Weekly list item 11.
The WPC number 18303 of 2014, the connected matter. Let this matter yes be called
10?
18303 of 2014. I'm serving a copy, extra copy to government.
But I am for the respondent. The suit out of which this appeal is carried, my lord, has been withdrawn by the plaintiff herself.
Oh, I see. Then nothing survives, sir.
But by order dated 17/10/2015, she has withdrawn, unconditionally withdrawn the suit itself.
All right. Counsel, the opposite parties points out that the present appellant has herself unconditionally withdrawn the suit being
Suit number 654 of 2011.
654 of 2011 in the
on
court of
17/10/2015.
On
17/10/2015.
On 17/10/2015, pending in the court of the Civil Judge Senior Division.
But in that
Cuttack.
suit, a CMA is now pending, CMA number 245 of 2018 for restoration of the suit.
You've withdrawn, sir. Where's the question of restoration?
No, to set aside that order.
No, you should go to that court only and say that. Why file a CMA for that?
That is WPC number 18303 of 2014, the wires of the Stamp Act has been challenged, and that has bearing with this.
If the suit itself is withdrawn, then where's the question, sir? The challenge, the writ petition was to the virus of the Stamp Act.
The suit is pending. Suit is pending.
He says
No,
it's
no, my lord.
withdrawn, sir.
Suit has been withdrawn at our instance.
That thereafter is
Arising from the
filed.
filing of the said suit, if the suit itself stands withdrawn to the question of the praise in the writ petition, and thereafter, and thereby the present writ
CMA
appeal
number
being entertained.
245 of 2018 is now pending.
Sorry?
For setting aside, the prayer is setting aside of the withdrawal order. A CMA has been filed that is pending and posted to today.
Once it is withdrawn under Order 23 Rule 1, unless liberty is granted,
Correct.
he cannot set aside that.
In that view of the matter, the present writ appeal is disposed of.
The withdrawal has been
Mr. Kara states
challenged.
that a CMA has been filed for recall of the withdrawal order. Depending on the outcome of the said CMA, the present writ appeal can be revived.
Yes, that is.
My lord, I will permitted in the writ appeal, the buyers of the Stamp Act, which has been decided by the Honorable Single Judge in WPC number 14123 of 2012, against which this writ appeal has been filed. In WPC number 18303 of 2014, buyers of the Stamp Act has been challenged. And that is most vital so far this writ appeal is concerned. It has nothing to do with the withdrawal of the suit.
Why not, sir? Because the suit you could not pay the stamp duty, only you filed the challenge to the Stamp Act.
I'm not.
The challenge
Your
is
academic
only
challenge
arising
is not
out of that civil suit.
Yeah,
It is only arising out of that civil.
In fact, in your writ petition, you mentioned the civil suit.
The Law and Trial Court has held that I am not liable to pay stamp duty.
All right.
And the order has been passed by the Honorable Single Judge. Direction has been issued to unmark the exhibits. That is the crux of the problem.
If your suit gets revived, we'll see all that. Yes.
So unless that is decided,
we have to continue because 2 o'clock is a reference.
Weekly list item 12.
Item 12.
You are for the petitioner?
No, let's
none appears for the petitioner.
I am there, my lord, for the petitioner. Mishra is
yes.
Now, this is with regard to challenging the decision to terminate the petitioner without holding any inquiry whatsoever on the basis of a decision of the caste scrutiny committee, which got set aside subsequently by this noble court and remanded twice, and thereafter final decision that has been passed by the caste scrutiny committee was challenged before this noble court. The Honorable Single Judge has been pleased to decide it against the petitioner. However, that is pending in writ appeal number 440 of 2018. Now, my lord, so far as this case is concerned, Your Lordship, the challenge was to the order of the caste scrutiny committee. My lord, pursuant to the order of the caste scrutiny committee, the termination order was issued without holding any proceeding in terms of section article 311 of the Constitution of India. I am conscious of the fact that 2004 Supreme Court says that once there is an inquiry by the caste scrutiny committee, that will amount to an inquiry, and therefore a face inquiry is not necessary and termination order can be issued. But this caste scrutiny committee decision on the basis of which this termination order was issued was subsequently set aside by this noble court. Matter was remanded for fresh consideration. Again, the caste scrutiny committee did not take into consideration the documents that was filed, and the matter was again remanded in WPC number 8621 of 2008. And ultimately, the final decision is pending in this writ appeal. Now, this order was challenged before the learned State Administrative Tribunal. That was possibly not a correct approach because the tribunal at page 60, Your Lordship will find, held that I should move this noble court and it is not competent to decide, because that will, Your Lordship will find page 62, paragraph 3. Even as per the decision of the Madhuri Patil case also, a writ petition is to be filed, and writ petition was filed. Now, my lord, the entire thing will be depending on the decision in the writ appeal. So may I, my lord, humbly submit that since instead of, my lord, questioning here the tenability of 10/4/2007 order,
yes,
which, in my humble submission has got effaced because of the fact that the decision of the caste scrutiny committee, which has been referred to at the top, Your Lordship will see, that is in pursuance of the letter number 12100 dated 22/3/2007, and the decision of the caste scrutiny committee that has been referred to, that decision was set aside. So therefore, this order also, in essence, has to go.
Not survive.
Doesn't survive.
Right.
They can issue a fresh termination order that will be different in pursuance of the final decision, which was challenged in the writ petition. And now, my lord, there also the question would be whether the writ petition should have been heard by the Honorable Single Judge or Honorable Division Bench. I think subsequently it has been clarified. So therefore, my humble submission would be, so far as this decision 10/4 is concerned, it has no existence in view of the fact that the decision of the caste scrutiny committee on the basis of which this was passed is no more in existence, that was set aside. Approach to the learned tribunal was wrong because it should have been before this noble court, that was rightly. And now before this noble court, this is being challenged in this writ petition.
No. So what's the long and short of it, Mr. Mishra? So you don't want to press the praise in the present petition?
I am praying, my lord, Your Lordship may kindly observe that this, so far as this 10/4/2007 order at page 58 is concerned, that has no existence in view of the fact that
No, you're also challenging an order of 22nd January 2013. What about that?
That is, my lord, Your Lordship, the learned tribunal held. I approached the learned tribunal challenging this order dated 10/4/2007.
All right. You say, counsel for the petition points out that in view of the subsequent developments, the challenge to the order dated 10th April 2007 of the tribunal, of the Central Administrative Tribunal, does not survive.
State Administrative Tribunal.
State Administrative Tribunal does not survive. The petition is accordingly disposed of.
I was only praying for one more clarification subject to Your Lordship's kind consideration. In this writ petition, both the order dated 10/4/2007 terminating my service has been challenged also. Your Lordship may kindly see the prayer. So I was submitting before Your Lordship, so far as the order of the tribunal is concerned, in view of the decision of the Madhuri Patil case, that challenge before the tribunal was definitely not a correct approach. But this order dated 10/4/2007, whereby my service was terminated without adopting any procedure in view of the decision of the caste scrutiny committee, has to go, because the decision of the caste scrutiny committee on the basis of which this termination order was issued was subsequently varied by reasonable court, and I am not disputing the fact that again the decision was taken by them and third decision has been taken by them. So after the first decision, they have again decided twice after the remand was made by reasonable court.
No, because anyway, reply has not been filed. Oh, there is a reply filed.
Well, there is a reply file. If I may place.
You've got copies of the replies, sir.
Well, it's the counter affidavit filed on behalf of opposite party numbers 5 and 6, if my lords may see. At page 14, my lords, that is the
5 and 6 I have not been given copy, but 1 and 2 I have been given copy.
This was
Copy of the affidavit filed, then you take off all that. Copy of the counter affidavit filed on behalf of opposite parties 5 and 6 we provided to counsel the petitioner within 2 days. So you have the counter affidavit to opposite party number 1.
1 and 2, yes.
Rejoinder to the counter affidavits filed thus far. Be filed before the next date. 17th October.
Obliged.
Weekly list item 13.
May I please, Lordship? Though the matter is covered by your Lordship's earlier judgment, this is regarding imposition of the holding tax in Bhubaneswar Municipal Corporation. It's squarely covered by your Lordship's earlier judgment in Kalyani Maternity Hospital case.
Right.
So the earlier occasion they submitted that they have approached the Honorable Supreme Court and the matter is still pending. So accordingly, your Lordship had by last day, order dated 10th of March.
I think it still must be pending.
They say pending,
that is
but
pending before the apex court, but before that, may I submit one thing? My lord, in this case, Lordship kindly say, I think, my lord, your Lordship may not have 2 briefs. One brief may be there because it is kindly see the order dated 10/6/2020 in this writ petition. And then your Lordship will find order dated 4/9/2020.
Anyway, sir, the interim orders.
So what is the
and then, my lord, IA has been filed. What I beg to submit, this file. Just a minute, Mr. Acharya, please allow me. Please allow me to submit. This matter for reference has been attached.
Validity is under challenge. Filing has been made and it has been shown defective since last 1 year. Your Lordship, I checked up the last status, defective matters not refiled after 90 days. As per the Supreme Court procedure, Your Lordship knows they have not refiled.
Lordship kindly say, let Mr. Acharya allow me to submit.
Your Lordship's judgment and say that let it go to the single bench.
But
on 10/8, just a minute, Mr. Man. On 10/8/21, they filed the SLP. Court fees have not been paid. It is in the defective filing. It has not been refiled. They take the plea that it is pending in Supreme Court for last. 1 year has passed. More than a year has passed from the date of judgment. No stay, nothing. They say that let it go to the single bench. Very unfair.
Well, here in this case,
this is the latest status. I am filing it by an affidavit.
Well, this case was brought for reference in another case where the user fee was challenged. In that case, it was stacked. Well, at that moment, your Lordship will find in this writ petition, it is in fact was taken up by the Honorable Single Judge. And that matter here, no demand is there. A repentation was filed to decide on the question of holding tax. Then the commissioner has passed the order under Annexure 1 and that is challenged. And by order dated 10/6/2020, that order was stayed. Then subsequently that was also modified by the Honorable Single Judge on 4/9/2020. And that was directed that whatever the demand is made, at least for the time being, 50% should be paid. People have accepted this. They have accepted this. This order is still
clear. Let this.
Please allow me to speak. What is this? What is this? What is this? Why are you interrupting?
No, I am for the petitioner.
Why are you may be, but you may be. I have a right to say also. And this is the position. And so far your Lordship's judgment is there. But so far your Lordship's judgment is there. Your Lordship, so far that SLP is there. But because during that COVID restriction period it was filed. So that is why already as per the procedures, to refile an affidavit that is being filed also. Lordship, that may be taken up and that
the long and short of it,
here
SLP is stated to be still pending in the Supreme Court of India list on 7 September. All right.
Weekly list item
The
14.
interim order to continue.
Interim
The
order.
interim order is there, not
Yes.
to lapse.
Item 14.
My lord, 14 and 16 are both similar matters, my lord. That is regarding issuance of rejection of my application for issuance of nil deduction of TDS on the ground that
Okay,
has
file
been rejected.
replies.
My lords, I appear for OP5, my lords, OP4, my lords, and I have filed a counter on Saturday, my lords. It may not be on record.
Yes.
So therefore, my lords, it may be adjourned.
Counter affidavit of opposite party number 4.
In item 16, my lords.
In WP 35150 of 2021. That is Hindustan Unilever Limited. Be brought on record. Copies thereof be served on constant the petitioner.
Copies are already served, my lords.
Copies are served, my lord. No rejoinder may be required. Your lordship may fix a shorter date, my lord. I plead.
Same thing, sir. 28th September, 20 September.
Weekly list item 15. My lords, these matters are clubbed together, my lords, because
Yeah,
there's
14
order,
and 16.
but right now in the cause list, separate matters are being reflected.
That's right. But 14, 16 will come together, sir. Right.
Grateful. Item number
Right,
15.
15. Item 15, my lord, counter affidavit has not been filed.
My lords, the copy has not been served. That is
Copy has not-
precisely. No, copy has not been served. Let them serve a copy, my lords. Thereafter, I can file a counter.
Counter, who has filed counter?
Object party number 1 and 2 is to file.
We have not received it. You say counter affidavit for opposite parties 1 and 2 be placed on record to adjourn for the next date. The same rehabilitation assistance is coming
Yes.
when? 27 July.
27 July.
27 July.
Item 17.
Maybe. The last occasion, government advocate raised a point, my lord, regarding maintainability of the requisition.
We'll have it on some other days. Now it's running out of time. 2 o'clock, there's a reference.
Some other time, next week, my lord, I think. Any other day.
So you accepted your appointments.
No, my I have given some judgments, my lord. But there cannot be any waiver on against the fundamental rights. My fundamental rights have been
There's a
violated.
judgment of the Supreme Court of India, sir. He has referred to that judgment.
I have given, my lord. I have given reply. I have given the judgments, my lord.
Which judgments? Where are they?
I have given the note. I filed my list of the decisions I filed, my lord. A list of decisions already filed in the list, my lord.
You have this list.
No, I don't. No, I have served, my lord. List of decisions I have served.
Just give him another copy, sir. This is
No,
one
list of
page. You
decisions
can't give him another page.
My lord, earlier, my lord, I have a list of decisions have been mentioned. I have
You
already
don't-
filed that is
should
in
I
the.
record that you refuse to give this one sheet?
No, my lord. No, my lord.
You will give or you will not give?
I will give, my. I will give.
Ah. At the request of counsel, the petitioner who wants to cite certain decisions. List on 11th October.
Weekly list item 18.
Kindly see the previous order passed by your lordship, my lord.
In this case, we are appearing for the opposite party. Lordship, allow me some time to file a counter. We are preparing the counter. Lordship, give me at least a week time so that we can prepare, file the counter.
Who were you for, sir?
I don't object to the prayer for filing counter.
I am
It's a
appearing
case-
for the OP number 8.
It's a case, if your lordship will appreciate the last order, that the one IS officer service is extended in violation of the Banking Regulation Act and other provisions of law. So keeping at 1 year extension. So today we are in the month of July. My extension is up to March. So let them file counter within a short time.
All right. Counsel for the opposite party number 8.
My lord, I will also file counter.
And
State has required also
opposite
state.
party number 3.
3.
OP number 8. I am appearing for OP number 8.
Seek and
I
granted.
am for opposite partner 1 to 3. Chief Secretary
And opposite parties 1 to
and
3.
GA
Seek and are
department
granted
and
3 weeks time.
Cooperation Department.
2 weeks time to file the
weeks.
respective replies. Rejoinder if any before the next date. 23rd August.
23rd
August.
Yes, no problem.
Weekly list item 19.
18, 19.
So this is basically a fundamental question of Article 13(2) versus Article 368(3), which is
What's the context in which you are raising this, sir? Why are you suddenly raising this?
so it's basically because the opposite party or the executive is actually utilizing the powers under Article 363 and 31B for amendment of the Constitution with regarding Part 3 of the Constitution.
What is that? What have they used? What have they in the recent past? What have they done?
Sorry, sir.
What have they done in the recent past that is?
Sir, actually, I'll tell you. Recently, in 2020, 12th June 2020, there was a judgment regarding the 69% reservation in
12 June 2020 is 2 years ago, sir.
Yes, sir. So, wherein the Supreme Court had remarked that the reservation is not a fundamental right. So, upon which those
you're now challenging, succumb to the prayers, you're challenging the validity of the 24th Amendment Act. 24th Amendment Act was passed long ago.
Yes, sir.
And this has been upheld, if I'm not mistaken. 24th Amendment has been upheld by the Supreme Court.
Yes, sir. It has been upheld by the Keshavananda Bharati judgment, sir.
Then how can you challenge it again here, sir, in the High Court? It's all misconceived, Mr. Goswami.
Sorry, sir?
It's misconceived. Your prayer is misconceived. This very amendment has been upheld by the Supreme Court of India.
No, sir. Actually, if you look at page 8, sir, of the petition and point number 4.18, I've said, sir, that either 32 overpass 368.3 or...
Sir, all that will become an academic discussion because come to your prayer clause, sir.
Yes, sir.
You're now challenging the 24th Amendment Act, correct?
Yes, sir.
This has been upheld in Keshavananda Bharati.
So, Keshavananda Bharati...
You cannot question this in the High Court. All we are trying to tell you is you cannot question a judgment of the Supreme Court in a High Court.
Okay,
Are
sir.
you a lawyer?
No, sir. I'm just a law graduate, sir.
So that's the problem, sir. So you need to either consult people who advise you correctly.
Actually, my point is, sir, at that time, whatever questions were raised on the validity of fundamental rights.
Go to the Supreme Court being a superior court to the High Court,
Yes,
the
sir.
High Court being bound by the judgments of the Supreme Court. If you are requiring that the Supreme Court should reconsider its judgment, you can only go back to the Supreme Court.
Okay, sir.
Counsel for the petitioner who appears in person seeks leave to withdraw this petition with liberty to seek other appropriate reliefs in accordance with law.
Lordship may also reflect the act has been enacted and Supreme Court has observed. That may be observed on the order.
Nothing more needs to be observed, Mr. Bari. You say dismiss this, withdrawn with liberty is paid for. All right.
Vehicle list item 20.
Appearance of union noted.
All right.
My lord, item number 20, I am before your lordship for a direction to the opposite party number 1 and 2 to give instruction to the print and electronic media not to publish, propagate anything relating to the marital dispute of the petitioner.
How is this coming before the division?
My lord, this is my
What is it? Why is it before a DB here?
My lord.
Why is it before a DB here?
My lord, they filed
challenge to
one
the
more
virus.
writ petition.
And
1 minute, sir. Why is it before this?
because it is a violation of my fundamental right.
No, it's not a PIL. It's not a.
No, it's not a PIL. It is violation of my fundamental right.
List before the appropriate bench.
My lord, my submission, may I just say, a writ petition can't lie against between a husband
Anyway,
and a
this
wife.
is not before. It's not supposed to be listed before this bench at all. So we are asking the registry to examine whether it should go before a single judge. All right.
No, my lord, earlier it was listed before the division bench and the order has been passed on 27/5/2022.
Where is that order?
My lord, that order is 25/7/2022, wherein this honorable court was pleased to
Where
pass.
is that? Where is that order?
My lord, 27.
But this was during the vacation.
Yes, during vacation. Because this is, since it relates to the violation of my fundamental right.
No, but it doesn't have to go before a division bench at all.
My lord, I think it will be before the division, or if it will be listed before the single bench, I don't have any problem.
Because that was during the vacation, probably they didn't realize.
No, during the vacation also there was a division bench and single bench were functioning.
I know, but doesn't mean that they are bound by that, because it may not be correctly listed. Given the subject matter of the relief sought, the registry is directed to place this before the roster bench of the learned single judge on
Day after tomorrow.
day after tomorrow. On Wednesday.
My lord, can it be on Monday?
Okay, next Monday. Next
My
Monday.
lord, interim order
Yes,
is there.
my lord,
So if it
can
is
you-
there, it is there. Why are you bothered then?
My lord, can
then
your lordship
it may be,
note my objection?
my lord, it may be listed along with the contempt application. May I give that number?
No. We're not doing all that.
Then your lordship may
My
keep
lord,
it.
also my objection to maintainability may be
That is
Not
noted.
necessary, Miss Luthra, that we are not passing any other order, simply saying it should be listed before another court. That's all.
Day after tomorrow.
She wants it for next Monday. All right. Next Monday.
Yes.
Weekly list item 21.
Great.
Right.
Item number 21.
My lord, sir, this matter takes some time. my lords.
Yes. Yes. List on. List on 10th. Okay, 3rd August. You take a chance on 3rd August. Sir.
Third.
Item 22.
Your Lakshmi, can you peruse flag K? As per the noting laws, he has been prematurely released.
You see, it appears that the appellant has been released prematurely. The appeal is accordingly disposed of.
Item 23.
Item 23 minutes, will take some time.
All right.
The last occasion I have given copy to my friend.
All right.
Either tomorrow or any other day, my lords will fix.
17th August. Sir.
My lords.
17th.
Item 24.
Today, filing the
Sorry, we'll have done 24th August. Sir. 24th August. Sorry.
Weekly item 24.
24. In compliance of order dated 29/3/2022, today I'm filing the compliance affidavit of the collector Cutter.
Collector Cutter?
Yes.
All right. The compliance affidavit of the collector Cutter is taken on record. What does it say, sir?
No, we have filed, we have indicated, we have given the map, you're looking at the page 6. Page 6. Annexure A by code. You'll see color page, you'll see can see. Last page.
All right. This will have to be examined, sir. All right.
Because all these constructions have been made much before the notification.
Anyway, you have to serve a copy of the affidavit be served on counsel of the petitioner.
I am for the Union of India acquisition.
All right. And the other counsel of the other parties. List on 5th September.
Item 25.
There's a jigs here.
No. This has been referenced today.
I know. Correct.
This has been referenced today.
Correct.
Well, it's 1st of August or 8th of August, subject to your lordship's convenience.
Can it not be later?
Lordship's may accommodate us anytime.
29th August.
Yes. I'll not detain your lordship. I'll tell them.
Monday.
Very well.
If not 29th, 5th September.
No, the 29th is all right.
29th August. All right.
My specific I will noted.
Yes, Mr. Chiman.
Lordship. All right.